Mr. Sabait?
Hello.
Mr. Sabait, I'm Mahesh here. A
Ah,
serial
good
number.
morning. Ah, serial
I have
number
one.
40.
I
40.
have knee replacement surgery. I'm not able to come to the court for another
Ah,
2 weeks. Yes, told that all these matters have been settled in Lok Adalat. So I just
my
want you to from your
my matter
client,
is
sir.
not settled.
Your matter is
My,
not settled.
my matter is not settled. Only in
I have
respect of
all
two
matters.
persons.
Pardon?
Only in respect of two persons, it is settled before Lok Adalat.
Uh-huh.
And my party is dead. It is not settled.
Okay, I'll find out that. That also will go before Lok Adalat. It will be settled there
Ah,
because what I was given to understand by the commissioner is that almost all the matters have been settled in Lok Adalat. Anyway,
ah,
this I'll put this
oh,
specific case I'll put across to him. And if there is any other matters of here which has not been settled, if you can kindly send me the list of it, I will speak to him and we'll settle it.
okay. Okay.
I've undergone a knee replacement operation on
Okay.
Thursday. I'm
Ah,
not able to move about.
okay. Wish you a fast recovery, sir.
Thank you. Thank you.
So today you are going to take time?
Yes, I'll take time.
Okay.
Yeah. In the meanwhile, if you can send me the list of matters which have been settled and not settled.
Okay. That I will send it to you. You can send me your telephone number.
ಡೇಟೆಡ್ ಸೌಂಡ್ ಅಂತ ಹಾಕಿದ್ದೀರಾ ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ಡೇಟೆಡ್ ಸೌಂಡ್ ಅಂತ ಹಾಕಿ ಇಲ್ಲ ನಿಮಗೆ ಕನ್ಫ್ಯೂಷನ್ ಆಗುತ್ತೆ ಹಾಂ ಅದೇ ಎಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಒಂದು ಸ್ವಲ್ಪ ಎಲ್ಲೋ ಬರುತ್ತೆ ನಿಮ್ಮ ಬ್ರಾಂಚಿಂದು ಒಂದು 4-5 ಇದೆ ಪಾಸ್ವರ್ಡ್ ಹಾಂ ಅದೇ
ಡೇಟ್ ಇರೋದು ಏನ್ ಮಾಡ್ತೀರಾ? ಡೇಟ್ ಇದೆಯಲ್ಲ
ಕೇಳ್ಕೊಂತೀನಿ ಒಂದ್ಸತಿ ಮೇಡಮ್
ಮೇಡಮ್ ಇರುವಂತೆ ಆ ಥರ ಕೇಳಿದ್ರೆ 20ಗೆ ಮಾಡ್ತೀನಿ. ಮೇಡಮ್ ಇರಂಗ್ ಬರ್ಬೇಕಾದ್ರೆ ಮಧ್ಯಾಹ್ನ ಚೇಂಬರ್ ಅಂತ ಕೇಳಿದ್ಕೆ ಗೊತ್ತಿಲ್ಲ. ಅದಕ್ಕೆ ಇವತ್ತು ಕೇಳ್ಕೊಡಿ ಮೇಡಮ್ ಇರಂಗೈತೆ. ಸೀರಿಯಲ್ ನಂಬರ್ ಅಂತ ಈಗ ಹಾಕಿಲ್ಲ ಅವರು ಹಾಕ್ಬೇಕು ತಾನೆ
ಅಂದ್ರೆ ಮೊದಲೇ ಕ್ಲೋಸ್ ಮಾಡೋಣ
ಅದನ್ನ ಯಾರು ನೋಡಿರಲ್ಲ ಮೇಡಮ್.
ಇವತ್ತಿಗೆ ಜಾಸ್ತಿ ನಾಳೆ ಜಾಸ್ತಿ ಏನ್
ನಾಳೆ ಸೈನ್ ಮಧ್ಯಾಹ್ನ 7 ಸೈನ್ ಮಾಡಿಸ್ಕೊಂಡಿಲ್ಲ. ನಾಳೆ
ಇಲ್ಲಿದ್ರು ನಾಳೆದಾ
ನೀನಾಗ್ಲೆಲ್ಲರೂ ಆ ಕಡೆ ಇಟ್ಕೊಡಿ ಮೇಡಮ್.
ಸರ್ ಅದೇ ಚೇಂಬರ ಧಾರವಾಡ
ಒಂದು ಬಾಟ್ಲಿ ತಗೊಂಡು
ಧಾರವಾಡದಲ್ಲಿ ಆಗಿಲ್ಲ ಮಾಡ್ತಾ ಇದ್ದಾರಲ್ಲ
ಮೇಡಮ್ ಅಷ್ಟು
adjournment Page number 7, serial number 26. Page 8, serial number 27 to 30.
My Lordship, serial number 27. I'm appearing for petitioner.
I'm for respondent.
I request 2 days time. Lord.
Wait, what is that? Which item?
Serial number 27.
Hmm.
Request 2 days time. Day after tomorrow.
At the request of non-counsel, the petitioner lists this matter day after tomorrow.
Let's serial number 29, my lord, and for the petitioner.
Hmm.
I seek a short accommodation, my lord. The opposite side has been informed, my lord. Due to
There should be a reason for a short.
some emergency, my senior had to leave town, my lord, that's why.
When do you want?
A week's time, my lord, anytime.
List this matter on Thursday. Next Thursday. Yes,
Page
Let's
number
see, no,
9,
serial number 24.
yes,
24 is not.
yes.
Let's serial number 24, Lord.
No
Let's
adjourn- no mentioning in dismissal
let's
matters.
the counsel for the my lord, the appellant, the petitioner, my lords, he is a government advocate now, my lords. And my lords, he has called me, my lords. He is supposed to hand over the files today, my lords. My lords, kindly, my lords, have it, my lords, next Monday, my lords. I will go ahead with the matter, my lords, without any this thing, lords. Since he has become the government advocate, my lords,
List it on Thursday, next Thursday.
public lords,
Not next Friday, not Thursday.
public lords.
Yes,
Page number 9. Serial number 31 to 34. Page 10, 35 to 37. Page 11, 38, 39.
39, my lord. I'm for the petitioner, my lord. Petitioner reported to be dead, my lord. 2 weeks time may be granted, my lord, to bring the LRs of the petitioner.
it is submitted that the petition is no more. The list is matter of 2 weeks for taking steps.
Okay.
Give a date.
22.
Yes,
Page number 11, 12, 40 to 45. Page.
why? How short the adjournment? This is on Friday at the request of non-counsel of petitioner. Inter-alia granted is extended till then. Yes,
Page number 13. Serial 46 to 51.
Your Lordship, serial number 49 for the petitioner, Your Lordship. We have informed the other side, prefer a short accommodation of 10 days, Your Lordship, due to my senior being out of station. Your Lordship, interim order may also kindly be extended. Serial number 49.
all these adjournments have become a routine practice. We don't have to list these matters. Yesterday also, half of the list is adjourned. 49. First on 20th,
Interim order may kindly be extended.
inter-alia granted is extended. Yes,
Number 14, serial number 52 to 54.
for the list.
Page 1.
My lord, on submission,
Serial
my
number
lord. Serial number 23 is the withdrawing, my lord.
Take that.
23.
23.
23, my lord.
The memo is filed to withdraw the petition.
Please.
Memo is taken on record. Petition dismissed as withdrawn. Yes. For the list.
Yes. Page 1. Serial number 1, Sri Hari K. For petitioner.
Yes, my lord. Serious matter, my lord. Application filed for police protection based on temporary injunction, my lord. No, my lord, I've taken instructions. My instructions are that, my lord, the impugned order has already been implemented. And my lord, with police help, already the plaintiffs are using the pathway.
I have to verify, my lords. I do not know. Irrespective of that fact, my lords, this order cannot stand the scrutiny of this honorable court, my lords. Irrespective of that fact,
Already worked, no, that's a different aspect.
Please,
We will look into.
that I will check it.
When already it worked out, then what is the significance of it now?
No, that part, because I could not contact I tried.
Please
Please,
contact, that
please.
will record both.
Yes,
How it is unsustainable,
yes,
as well as how it worked out.
please,
Yes,
please. Could it be next week, my lords?
yes.
Please.
This is matter on next Friday at the request of non-counsel, the petition in the same caption. Yes, next.
Grateful.
Bill number 2. Stanley Sam for petitioner.
Your Lordship, appearing for the petition in this
For
case,
respondent.
my lords.
Yes.
as per this court's order, I think the respondent father has exercised the rights.
Hmm.
And again, the child requires some time to heal, your lordship, and we should give some space for her to get it healed. '21st as well as 23rd, it was exercised. And the next 28th, it was not, I think, because respondent was not available as well as counselor was not available.
Respondent was available. It was a
Respondent
counselor.
was available, but the counselor, my apologies for that, your lordship.
Yes, what do you say, Pratim?
Let's going forward, if your lordships could just interact with the parties and the child, because the current report, I'm not aware of that. And then whatever your lordship suggest would be appropriate is what I feel, my lords.
Yes, Mr. Stanley.
Your lordship, I also don't have any hesitation in that one. Only thing is January 13th to 25th, she has got exams and she has attained the
Have you-
puberty by
I think you
3rd.
better have a look at this report also, what the counselor said. Both of you have a look at this report,
Please, your lordship. Please, your lordship.
Then you will
Sure.
understand what is the situation and what is to be done.
Please, your lordship.
The
Plus next week,
registry-
any date
the registry.
Your lordship, maybe
Let her exams be completed. Let her
please, your lordship.
write the exams.
whatever your lordship
When,
suggests.
when the exams are going to be completed,
25th, your lordship.
we'll have this matter on 29th.
Please, your lordship. Greatly obliged.
It is submitted that the girl is having exams till 25th. Let's this matter on 29th of January. Both the registry is
Your
directed.
lordship, a direction may be given for giving the report also to
That's
us.
please wait. The registry is directed to furnish the copy of the report dated 6/1/2025 to both the councils. Yes, next.
Greatly obliged, your lordship.
Till number 3,
For the petitioner in this case, my lordship.
Happiness. For the respondent in this case.
My lordship, we are given to understand that the visitations are going on well, my lordship.
Since the last occasion, my lords, out of 4 occasions, 1 occasion only last Sunday they have met because they were not keeping well. Either of them were not keeping well. Otherwise, he met the child for 2 hours last Sunday. And the child
So what is to be done?
My
Then
lords,
let this order be made, we'll make it absolute and let the matter be proceeded by the trial court.
My lord, one more concern is that he doesn't have the access to the child's education in the school. She has given a letter to the school not to allow him to any of the school function. He cannot
No.
even.
What was that you asked before the trial court?
We have filed application was for the visitation.
So let's not stretch it too much.
10 a.m. to
No.
4 p.m. at least, my lord. 10 a.m. to 4 p.m. at least, my lord.
What was the
Visitation.
time?
10 to 1 it was initially, then 10 to 2 now.
No, Mr.
My lordship, it is already extending beyond it, my
No,
lordship.
no. Please get instructions. We'll dispose of this matter. Let the family court decide the issue. Like that, with regard to that visitation, between one day on Sunday, it is happening. On Sunday, from 10 to 4. Just get instructions on that. We'll pass
will
that
do that.
order and without any further interlocutory applications, let this arrangement go on and let the court itself decide the main application.
I'll seek instructions, my lordship, from my
When
client.
do you want?
Any date convenient to this court, my lordship.
Day after tomorrow. Place this matter day after tomorrow for the request of land counsel for the petitioner.
Oblige, my lordship.
Say number 4. L. Lakshmi Rao, G. Lakshmi Rao for petitioner, M. Srinivas for the respondent.
Or the petition counsel, my lord, is the letter written by the trial court for extension of time.
We ordered it 30th September 2022. Ordered bench of this court had directed the trial court to dispose of the matter as expeditiously as possible and shall not exceed 1.5 years from the date of receipt of a certified copy of the order. By letter dated 27/2024, the learned judge has requested for further time for disposal of the matter, stating that in this disposed of matter, the original records were already destroyed. And she had to record all the evidence for that time. She requires some more time. Considering the same, another 6 months time is granted for disposing of the matter.
I call you. Right.
Yes, please.
5. Chandrasekhar for PV for petitioner.
For the petitioners, my lord, we have paid the process fee, my lords. And
It's
steps to,
submitted that then what about the steps?
we'll take the steps, 2 weeks' time may be granted for.
It is
take-
submitted that they've already taken steps for service of notice to R1D, R3D, R6A, D, E, F, and G. Next, it is submitted that they'll be taking steps in respect of the deceased R3 within 2 weeks. If the steps are not taken, the petition shall stand dismissed as far as R3 is concerned. Even for next R2 also, same order.
Serial number 6. T. Sheshgiri Rao, petitioner.
My lords, I have to file the necessary applications, my lords, with respect
Learned counsel for the petition shall come up with appropriate application for substituted service by 20th of January, or else the petition shall stand dismissed without further reference to the court. Yes.
Serial number 7. Govind Raju L. For
Applying
petitioner.
for the petitioner, my lord.
You have taken out notice.
I've taken out paper publication in Times of India, my lord, but at the time of, it was 2 paper publication has been mentioned, my lord. I'm filing a memo to dispense 1 paper, my lord, that is.
This court of by order dated 19/8/2024 had permitted the petitioner to take out notice in Times of India and Vijay Karnataka Kannada Daily Newspaper. The petitioner has filed before this court the copy of the paper publication dated 31/8/2024. The same is taken on record. Notice to R2 is held sufficient. Then what about Vijay Karnataka? You asked for it.
Lord, but oversight, it was 2 papers, my lord, but the R2 even is preferred and writ appeal, my lord, he is the party is well aware of this case, my lord. He's just dragging on the proceedings.
No, that order needs to be reviewed.
Lord, that hence I'm filing a memo, my lord, because twice it's economically burden and
Then who asked you to ask for such a direction?
this, my lord.
Then council submits that instead of asking for 1 paper, by oversight, they have mentioned 2 papers. As such, they have filed a memo to dispense the paper publication in Vijaya Karnataka. Consider, it is submitted that the respondent has already preferred an appeal, and he is already aware of the pending proceedings. Considering the fact that already in
Not to this, my lord, but with regards to same suitable property, it was, the respondent was preferred an appeal, that is it, 6/1
considering
of
the fact that
2017.
already in 1 newspaper, he has taken out notice. The memo is taken on record, and as far as the notice in respect of the Vijaya Karnataka
Please,
is dispensed with.
interim order may be extended.
Interim order earlier granted is extended. Next,
Serial number 8.
list this matter in the name of so and so, that the respondent, and list this matter on 21st. Yes, next.
Serial number 8.
Even
Usha NB.
it have taken 3 times steps. It will 10 days time.
20th.
21st.
List this matter on 21st. By the time the petitioner shall come up with appropriate application for the substituted service, or else the petition shall stand dismissed
Serial
without
number
further
9.
reference to the court. Yes.
9.
As against respondent of 2,
In
because
as
they are
against
husband
respondent
and
number 2.
they are husband and wife. Anyway, that I will see that it is so.
Yes. Next.
9. VB Shivkumar. Yes.
In this matter, my lord,
Yes,
the earlier counsel, my lord, VP Shivkumar has issued an NOC. Today, I had received an NOC file. A week's time may be granted. Meanwhile, I'll comply the office objection and will come back.
It is submitted that, what is your name?
B. Rupesh.
It is submitted by the learned counsel, Mr. B. Rupesh, that he has received the NOC vakalat and he will comply with the office objections within a week, same default order. Yes, next 10.
Serial number 10. Badrinath R.
My lord, kindly have 2 days time to take steps for R4, my lord.
Why for this a memo is moved?
Apology.
You should have taken steps, sir. A week's time is granted for taking steps. If this, yes.
Serial number 11.
Interim order has
Default
to be
order.
extended.
Interim order only granted. Look at it. If it is extended on the last occasion, then only. Yes.
I am for the petitioner, I will take proper steps.
My lords.
By way of paper publication.
Suit is of 2009. The proceedings have been stalled for the past 6 years, my lords.
When the deceased died,
I will,
the R4 died.
or for dead, 1 year back.
Then what are you doing?
I will take paper
My
publication.
lords, this has been listed twice before.
ARP of 2018.
Yes, ma'am.
Finally, this is smart, finally, the petitioner shall.
Within a
is
week, I will
granted,
file necessary application.
Time till 20th for taking steps.
In while interim order, ma'am.
If the steps are not taken, the petition itself shall stand dismissed.
May I request-
Without further notice, to this court, interim order earlier granted is extended till then.
My lords, may I request for a date to be fixed? The reason being, my lords.
I
since-
said 20th.
20th.
Grateful.
Cell number 12, Raja L for petitioner. G. Chandrasekharaya.
Pray for 10 days time to steps or two.
Actually, what remains in, stays there in this,
Yeah.
2019 CRP.
Now file the application year 2021. Office not put up the application. I filed the application in time.
What is the application?
R4 is died, my law. LR application is filed in time.
It say, no.
Hmm.
To issue notice to R2, R4 and R5.
Yes.
When you are for R4, you are saying that you have taken steps. What
Steps.
about R2 and R5?
2 times I already taken the steps, unserved. Now is 3 times taken the step RPAD. Otherwise, I will paper publication.
So, first of all, for steps in respect for pay, the petition shall pay process in respect of R2 and R5 by 20th, or else the petition shall stand dismissed as far as R2 and R5 is concerned. Next, in respect of R4, it is submitted that already has filed a petition to bring the LRs on record, list that list the petition tomorrow.
Application is there.
Application is, the copy is not served. Issue notice to the application, I will take.
Copy to whom it has to be served?
R1 copy kottilla. There is.
Do it and it will come tomorrow and we'll issue notice.
The issue notice, other copy ready there, but respondent is not there.
Why you don't know this advocate?
No.
Take that IA. Serve on him.
No. Actually, which procedure prakara is LRs only notice. Respondent one now copy is not necessary.
Is it put up? One of 23. Sure. Notice in IA1 of 2023.
Interim order extended.
Interim order earlier granted is extended. Look at it if it is there. Yes, next.
Cell number 13. Cell number 13. Rashid Ahmad.
No representation for dismissal tomorrow.
Cell number 14.
I appeal for the petitioner. I pray for some time to take steps for R31. And I'm told the matter is referred to local.
Will grant time till 21st.
Much obliged.
For taking steps in respect of deceased R31. Shall take steps in respect of R31 by 22nd of January, or else the appeal shall stand, the petition shall stand dismissed in respect of the respondent. Yes.
Cell number 15. Vinod Reddy for petitioner Chandrasekhar Patil.
Yes, no representation for dismissal tomorrow.
Cell number 16. G. Shankar.
I'm offering for petition, madam. Kindly press time for 1 week, madam.
1 week in respect of R3. Then what about deceased R2?
Deceased R2, I take step, proper step, my lord, kindly.
This respondent, I am appearing for respondent number 7. He is the contesting respondent. All of the other defendants have sold the property to me. And he files an application after selling the property. there are 2, 3 sale deeds. Then he files an application for amendment so that he has not executed the sale deeds. Earlier also, he has taken the same contention. Now, if he has not sold the property, he could have filed a separate suit, even it's on a merit. But now they are not necessary since I am the contesting respondent. The property is in my hands.
Interim order is there.
Interim.
We'll hear this matter then.
My lord,
Then we'll understand.
kindly 1 week, my lord. My colleagues are due to inconvenience today.
Then we'll have this matter on Friday, next Friday.
Please.
Then that day we will decide whether all these steps are required or we'll
Please.
for dismissing that we'll see. We'll see.
Yes.
Next Friday.
Please, interim order, my lord.
Interim order earlier granted is extended. List this matter on next Friday. Yes, next.
17.
I paid PF as against respondent number 10. Respondent number 10, and I have paid PF this morning.
Steps will be taken.
I pray for some time, my lords.
It is submitted that already needful is done. As far as respondent number 10 is concerned, it is submitted that R1 is no more and the LRs have to be brought on record. Finally, not finally, by 21st of January, steps shall be taken or else the petition shall stand dismissed as far as R1 is concerned without further reference to the court.
Interim order, my lords.
Interim order, look at it. Yes, next.
Number 18. 303. For petitioner.
Let's
18.
steps may kindly be let's take in last case 2 times I have taken the respond number 1 to 4 as family members. This is suit per partition. Let's I'll take district to service purposefully they are providing the service 22 minutes.
The petitioner shall come up with an appropriate application by 22nd.
Against 4 and 5.
Against
4 to 9.
In respect of the respondents 4 to 9. Or else the petition shall stand dismissed as far as 4 to 9 are concerned.
Interim order, kindly.
Interim order, look at it. In all the matters, whether the court says or not, interim order is there, extended.
Grateful.
Yes.
Number 19.
Appear for the petitioner, my lords. Here also, my lords, the respondents are family members. My lords, in the meanwhile, there is some urgency because one of the items of the petition schedule property is put for auction sale, my lords.
2020 matter when you have not taken. No,
Lord, I have taken steps twice, my lords, but.
No, it's only coming up for the second time. Only once you have taken.
Once I have taken.
Yes,
lords.
please do it. No urgency now.
Lord, say your lordship may permit me to serve it upon the counsels who are appearing before the trial court.
No, do it.
This is this reason.
Then
Because
counsel the petition is permitted to take notice on the counsel appearing for the respondents before the trial court and shall file a memo to that effect. Once the memo is filed, list the matter.
Lords, a short date, my lords.
That's what I'm saying. Once you file the memo, it will be listed.
Automatically, my lords.
Yes, next.
Still number 20. Hanumantara advocate.
Appear for the petitioner, ma'am. Kindly grant for a week time, ma'am. SIP has to be taken.
In respect of the unserved respondent R4 and also deceased R1, steps shall be taken by 22nd of January or else the petition shall stand dismissed in respect of R4 and R1 without further reference to the court. Yes, next.
Still number 21. YK Narayan Sharma.
Appeal for petitioner, my lord. Needful done, my lord.
Then counsel submits that the needful is done. List after
Interim order may kindly be extended, my lord.
the list after service of notice. Interim order earlier granted is extended. Yes, next.
Still number 22. Hearing on interlocutory application. Yes, Venkat Subbarao.
Petition in this case, ma'am. Delay.
Where is the respondent? We'll hear it tomorrow. No representation for the respondent. Counsel for the petition is present. This matter tomorrow.
Interim order extended.
Whether he is there or not, we'll hear the matter tomorrow. Interim order. Yes, next.
Still number 29 at 23 at default, 24 adjourned. Still number 25. 25.
Petition in this case.
Ranjit case.
My lord, the earlier counsel Ranjit case is expired. Earlier counsel Ranjit case is expired. So his name may be deleted in the list.
Delete the name of Mr. Ranjit case. History is directed to delete the name. Yes, you're ready?
Yes, ma'am.
Yes.
This suit is filed by the respondent for recovery of money of rupees 8,20,000
First, he has filed a check bounce case. After filing of the case, the
Yes.
appellant, that is petitioner, legal heir of petitioner, he has filed the present suit, present petition here. The complainant, accused has died. After that, they withdraw the complaint and they filed OS number 3 in 2011. That OS number 3 of 2011 is ex parte order, my lord. Notice is not served to the legal heirs of the deceased R1R. And whatever the claim amount is 8,20,000 is not borrowed by the respondent. So they have not taken any actions to the notice or service of notice and in
What is the
OS,
order impugned?
the impugned order is, my lord, I'm challenging the OS number 3/2011, that is recovery of rupees 8,20,000 with future interest, my lord.
Where is the
Annexure B, my lord.
Page number?
Page number 22, my lord. The order passed in senior civil judge at JMFC at Mandya. Annexure B is decree copy and annexure C is order copy, my
How
lord.
can you file a writ petition against the judgment and decree?
My lord, I have filed after the judgment and decree ex parte order, I have filed miscellaneous petition to restoration of the.
Where is that? That is the
Annexure A,
order
my lord.
impugned.
Annexure A, my lord. Annexure A, page number 10, my lord. It starts from 10. That I have challenged.
Let's see the reasoning. Please read.
My lord.
Read the reasoning part
Reasoning.
at page number 14.
The petitioner number 1 had retired the contents of the petition in the affidavit filed in the lieu of the examination in chief. Apart from the oral evidence, the petitioner have produced one document marked as Exhibit P1. Exhibit P1 is the certified copy of the order sheet pertaining to the proceedings in miscellaneous 19/2014. On suffering through the order sheet, it would be clear that the petition was presented on 2012-2014 and registered on 5/1/2015. The petition was made over to this court. It was argued that this court had no jurisdiction as ex parte decree was passed by the learned second additional senior civil judge Mandya. It would be clear from the document at Exhibit P1 that parties had appeared before this court and had contested the matter without seriously questioning the jurisdiction of this court. Apart from that, there appears no miscarriage of justice on this alone, and it neither pleaded by the petitioner. The case was posted for the evidence of the petitioner on 4/6/2015. The case thereafter adjourned to the 9/1/97/2000.
Heard the counsel for the petitioner. No representation for the respondent. List this matter as part for tomorrow. Yes.
Cell number 26, Jay Prakash Reddy M for petitioner, Prasanna Kumar P for respondent.
Waiting for petitioner. This revision petition is filed to review the order passed by Lordship's Malad in the writ petition number 27964 of 2023.
Yes.
Wherein Malad, in the writ petition 27964 of 2024-23, Malad, have challenged the order passed by the London Family Court judge, granting only rupees 5,000 to the as interim maintenance to the son and rejecting maintenance to the wife. Thereafter, Malad, your Lordship, while disposing of the 27964 of 2023, Malad, has enhanced the interim maintenance to 10,000 to the child and has refused to grant any interim maintenance to the wife only on the ground that, Malad, she is working as an advocate. Lakshma kindly similar that the wife is even as per the assets and liabilities as filed by the respondent here in Malad in page 75 is earning more than is earning 80,000 85 lakhs, 85,000 per month as a
The
rent.
doctor- No, he's unemployed right now.
Is, I'm not
He's only
saying.
getting, my lords, the rental.
How much will be, is it
84,000 is, my lords, the declared assets
per month?
per month.
And he is paying 10,000 to the
Child,
as per the order of the court.
please, my lords.
So he is left with another 74,000.
There is, my lords, first child, who is, my lords, he is with the first child is with the husband, respondent. The second child is with the wife, petitioner.
Yes.
The first child is major and he is 23 years old now. Now the second child is only 10 years old and even education expenses are also not paid till today.
Now, any material is placed before the court with regard to her income and her assets or.
Lords, I have, my lords, produced, my lords, the list of documents, my lords, on the last, my lords, on the previous
Yes.
date.
Number.
Lords, not, lords, made the date. Lords, I have produced, my lords, a list of documents. Separate, my lords, compilation was made. To, my lords, bring to the court's notice all, my lords, previous litigations. 3 times, my lords, she had approached for maintenance. 3 times, my lords, it was rejected. Thereafter, my lords, after a lapse of 5 years from, my lords, the family court's order, this writ petition was challenged, filed. This court, my lords, graciously enhanced it to 10,000. Thereafter, my lords, she again filed one more petition, my lords, application before the family court. Though there was, my lords, a specific direction by this court to conclude, my lords, the trial within 6 months. This is 2015 MC, my lords. Even to this day, my lords, it is at the same stage. On, my lords, the previous date, the coordinate bench, my lords, extended it to 1 more year, my lords, based on the request of the family judge. It was extended again. Now, my lords, there is one more application that is filed, seeking, my lords, permanent alimony. That will be, my lords, heard along with the final disposal. And now, my lords, another application is filed in the present petition, seeking, my lords, interim maintenance again. This is, my lords, done just to, my lords.
Interim maintenance, this court will not grant.
Please.
Because that's not the part of the review.
Please,
petition.
please. Now, my
The
lords.
Scope of review is very limited.
Very limited, my lords. In fact, I have, my lords, placed my lords, one judgment, go in Kandelwal, my lords, on the last date. It was, my lords, I had read it out.
One aspect.
Where, my lords?
No, no, your income is 74,000 after deducting 10,000.
After deducting 10,000.
Which you are paying to the son.
Yes, yes. No, my lords, my first son is, my lords,
with you, that I understand.
correct, he's
That I
doing his
understand.
masters. Currently, my lords, he's doing his masters. I've been taking care of him. I have, my lords, my aged parents to take care of. My lords, this is, my lords, my current situation. Then, my lords, with regard to the petitioner, my lords, my lords, she has also filed her assets and liabilities. David, I have placed everything on record, my lords. Even there, my lords, she declares, my lords, that she is a practicing advocate. 2 years ago, my lords, her income was, my lords, supposedly 5,000. Now, my lords, she has not filed the latest assets and liabilities. I have, my lords, filed my
No, we'll take it that her income is 5,000.
Lord, she is a practicing
Let's
advocate.
take it, no, let's take it that her income is 20,000.
Right.
Let's take it. Still, she, with this, for example, 10,000 plus what you're giving another 10,000. Now, can they live in a place like Bangalore?
Lord,
Can they live in a place like Bangalore with 20,000?
understand, my lords,
When you're in a proportion to give her something.
I am, my lords, making every effort to, my lords, get the MC disposed. That is one aspect. Secondly, my lords, she has been dragging, my lords, the matrimonial case, my lords, since 2015. It is, my lords, at the same stage. Since, my lords, 2019, 17.
Not me who is dragging, even.
Let the order sheet be, my lords.
Order sheet may kindly be looked into.
My lords,
Even you lords may kindly.
Oh,
No,
one minute.
Please, madam.
When
Please,
you're
please.
decided not to, whatever the strained relations, they should be a quieters. What does this learn for years together? dragging on? It is neither in her interest nor in his interest.
It's a wrong submission.
Mm.
My humble submission is, my lord, even after he tendered his evidence in the MC petition, my lord, filed by him for the decree of divorce, even after his evidence was led in, thereafter he has remained absent on so many occasions. I can establish.
I'm sorry, my lords, this is a false submission that has been made. Kindly take, my lords, the order sheet. I have produced the entire order sheet. Despite, my lords, the direction of this court, they again remained absent. I was again recalled, my lords. I was again recalled. Post the direction of this court.
I don't want to.
They have not cross-examined.
I don't want to keep on the litigation pending, and I would not want to do.
No, you want it to be disposed of, MC to be disposed of.
Please, my lords.
Please, my lord. I don't
Court
have.
directed for 6 months.
No,
They did not do anything.
My lord,
He was
after all-
present every single day.
after all-
And, my lords, they had also filed, my lords, one criminal miscellaneous under DV Act. That has been, my lords, 3 times the IA was dismissed. Now that has been dismissed for non-prosecution. And the conduct has been recorded. She has made a submission saying that she is suffering from arthritis for the 8 adjournments. And, my lord, she has been practicing, my lords, in the High Court every single day. She is not ready to, my lords, appear before the DV court, my lords. This is not what, my lords, the order has been.
As a single
case number
mother,
222.
it is not a privilege for me to keep on dragging.
8 adjournments, my lords. The
litigation
judge has
and
accorded it.
as due to pendency of the litigation, I cannot concentrate on my profession, or I cannot concentrate on the family.
Why don't there be like some via media or a compromise on this?
Lords, in fact,
So
settlement talk,
many,
my lords,
so
happened.
many.
What is that she wants
Lord,
for a settlement?
your my lords, my kindly similar. My learned friend is saying that the husband is unemployed and he is not having any work. Then
Let's not go into all these disputed questions. I just, one simple question is, what is that she wants for a settlement? No, not that she wants to join him. She doesn't want to join him.
she has filed a MC petition for restitution of conjugal
She
rights.
wants to join him?
Still, if he is ready to take, she is ready to go with him.
Lords,
But
settlement
he
talks
don't
happened,
want,
my
he
lords.
don't want
During, my lords, the
litigation.
review.
Married again?
No.
According to our information, he is married and he is living in a separate apartment since from 1 year.
No, my lords.
After
Let them file an affidavit to that extent. That is absolutely wrong. And, my lords, in fact,
Client is interested to join.
my lords, in fact, the settlement talks happened, my lords, a month ago. That was, my lords, a false submission that was made that no settlement talks happened when your lordships were in Dharwad. They made a submission that, my lords, no settlement talks ever happened. They have made a false submission. That is absolutely false.
Let
The
both
senior
of them-
advocates, my lords,
Let
chamber,
both of them come to the court.
please, my lords. Request it to be taken
This
up tomorrow, my lords.
not tomorrow.
Tomorrow, my lords.
Not tomorrow. Tomorrow,
My lords, there will be a quietest.
Might not be
Please,
tomorrow I will not
any
be
day,
in
my lords.
station.
Listen, matter on 22nd,
Lords, 22nd.
22nd.
Lords,
This is matter on 22nd at 5 o'clock in the chambers. Both the parties shall be present.
lords, one
Yes.
submission, my lords. Your lordships had directed me to file an affidavit. I had made a submission. There is, my lords, 1.12 crores that is pending in, my lords, in New Zealand.
And then there's
In
some
our,
order was passed.
some
What has
order was
happened?
passed. I had, my lords, cooperated. She has not come forward, my lords.
That,
There is,
that
my lords,
application, your lordship has directed them to file an affidavit regarding the procedure and other aspects. They have not filed any affidavit and or any application regarding that aspect.
your lordships were, my lords, kind enough to direct the petitioner to, my lords, consider this particular.
No, what's the difficulty when the money is lying there and when
Please,
you're
my
in
lord.
need of
Yes,
money?
yes, my lord.
But
That-
Why should, no, it's not that.
Maintenance charges is, my lords, deducted.
It's not that she's uneducated, that somebody has to tell her how it should be proceeded.
The procedure, my lord, even according to there, what has happened, my lord, so far as that amount is concerned, my lord, he is claiming so many other aspects. He is saying that he has borrowed loan from his manager and that he has to repay
The
out of this
fraction of
amount.
it, my lord.
That amount,
Hey, he made a submission
Action.
my
that
lord,
whatever is the amount, half will go to her
Irrespective
and
of
half
it,
will
my
go
lords.
to him. That's
please,
Irrespective
my
of the
lord,
outcome.
we are ready for that, my lord, only with one condition, my lord. Let whatever the maintenance charges that has been paid to the caretaker of that money, because it's there, the three trustees will be there, one wife, husband, and the banker or the advocate who is that. And that third person will be has to be paid for taking care of this. And we only that deduction, after deducting that amount, it can be divided equally among the both, as per the law of the land of the New Zealand.
Affidavit is on record.
Are you okay with that? Your client is okay with
A
that?
fraction, my lords, is to be paid as a loan to one person, my lords. One individual, my lords, 50, some
No, his
exorbitant amount.
submission is,
My lords.
after deducting what.
Correct, my lords. I agree to that.
We are ready with half and half of.
Half and half, my lords. There is one, my lords, submission. There is, my lords, I have made it in the affidavit also. My lords, Mr. One Wellinga, my lords, of a New Zealand resident.
22nd, by the time this matter comes up.
Will, my lords.
Court,
Please, my lords.
and he is ready to cooperate and you also cooperate. And as it is, accepted by him also, that after deducting whatever amount that has to be paid, the remaining amount, both of you can have. Why you want to pay this, for somebody who is a trustee for?
No, because now the problem is, my lord, he alleges that, my lord, he has borrowed some loan from somebody else, some manager or some of his employer, and there is no records for that and other things, and he is only self-serving statement,
Lords, I have filed
and
an
it is to
affidavit.
be paid
I-
out of the
Lords, I'll be
such part.
bound by it.
No, anyhow, that is, now the stage has gone. Please.
I have.
And
By the time when the matter comes before this court, there should be some positive
please.
steps
We'll
from
work
your
it out.
side,
And
or else that will also be considered by the court in passing this order.
no, that is totally different, my lord, because both of them are.
No, it's not like that.
No,
Because
because
there is a procedure available and everybody has a right to have the remedy. It doesn't matter. That doesn't mean that, you keep on litigating on something. You should be at a solution oriented.
Yeah, definitely, my lord.
Should be.
Definitely.
Why they are wasting their valuable time in courts and also the court's time where
Even
where
there
the
were-
problems
There are four
Already-
optional proceedings.
post this matter on 22nd at 5. By that time, the court wants to know what is the positive steps taken from your side.
Please.
Whether it fructifies or not is a different aspect. What is the contribution from your side to reach that, that conclusion?
That's very clear, my lord.
it.
Both
No,
of them are equal.
If he is going back or if he's taking a different turn, then you can tell the court.
Yes, my
If
lord.
this arrangement.
Even tomorrow itself, we are ready, my lord, off and off.
Yes, Mr. Counsel.
Lords,
He says, but tomorrow itself they are ready, do it.
Lords, my only submission is that, my lords, I have stated in the affidavit, I have annexed 3 documents to indicate, my lords, the loan.
Personal
That
mails
is,
and.
no, no,
Not the
no.
loan.
My lords, a loan of, my lords, 5,90,000 of, my lords, New Zealand dollars was availed as
It's-
loan to purchase the property, which
It
is,
is-
my lords, now sold and kept as, my lords, a joint mortgage amount. That is, my lords,
According
1.12
according
crores.
to him, it is the
But I
2014
have
loan.
produced the documents. That has to be returned to that particular
No
person. That is it, my lords.
no prudent person will keep quiet for
I have filed
this
my
emotional.
affidavit.
Loan,
No, that is a fraction of it, my lords. I will be very clear.
loan is something nobody can, you can't,
No,
you
it's-
can't
it-
cook up that story.
Yes, my lord.
Is it not?
For that, there should be some document, my lord.
Let them file
Documents.
If you file the document.
If he has filed document saying that there is a mail contact between himself and that lender, and not other loan documents.
Have the copy.
Not the copies.
No, my
All-
affidavit copy. my lords.
Although
Authenticated
not the-
document, any.
all the documents, any document to show
Hmm.
that there was a loan transaction.
Please.
And you must be having, if the loan of 5 lakhs is given, then it will be evidence that it will be some bank transaction or the statement will be there
Lords,
that
it
you
has-
can show, not
Please, my
this
lords.
kind of correspondence.
No, not a correspondence, my lords. It is issued under, my lords, the letterhead of the company which I was working in.
Not
He is, my
that.
lords, my senior associate.
Bank
I will ask my party to, my lords,
and
I will, my
give it
lords.
to them. If it
I
is
will, my
there,
lords.
then they have to accept.
My lords, I will
No,
definitely-
who will pay that 5 lakhs?
Please, my lords.
After that only, then the amount has to be shared between
If
the
it is for my
parties.
personal requirement or his personal requirement, that cannot be borne by other
Sorry, it
party.
is not 5 lakhs, my lords. It is
If it
1
is-
lakh, my lords. 1 lakh, I'm sorry. my lords.
Please wait.
1
The
lakh,
difficulty in the family matters are more than the clients. The advocates are more aggressive.
Sorry.
Now, if it is for a loan transaction, for what purpose it is given, it will be definitely. And by the matter comes on 20th or 22nd as directed, then please place before the court what is the development.
Please, madam.
Please.
Yes, next.
Cell number 27 urgent, cell number 28, Kansana Tariga K, for petitioner. Ravi Shankar ji.
Yes,
Here for the respondent. number
yes.
one, the dispute with respect to 11 cents of land, out of which 8 cents of land purchased.
Where is the advocate?
I met him, my lord.
No, she asked for adjournment on 27.
Please, my lord, I need 14 page of this 104, last date of hearing 2 days before. They suggested that any chance of amicable settlement. Accordingly, we consulted our clients as well as they given the note to that. In the meantime, it was informed to the opposite side. Now, with respect to the 2 cents and quarter cents of land is remaining. The court suggested, why can't you buy? We are ready to buy the market price. In the meantime, they suggested also. Now we have to sit and have the discussion regarding that aspect, how to go about it.
You want time for that?
Both the parties, both the petitioner as well as the respondent require some time.
When do you want?
2 weeks time.
It is submitted that there is the scope for settlement. This is matter on 29th of January. Yes, next.
29 urgent, cell number 30.
Yes.
Leeladhar HP, for petitioner. T. Sheshgiri Rao, for respondent.
Finally, place this matter on 20th, no further adjournments. Yes.
Sale number 31. E.A. Shrikante Gowda for petitioner. Shams Ahmed Patan.
But in this case, the application that was filed.
Yesterday's matter.
Yes, yes. The petitioners filed application in the final decree proceedings that was filed by the respondents herein. That is respondents 1 to 7 that my application came to be rejected. Though I am a necessary and proper party to the proceedings because
You have filed a complete petition in final decree proceedings.
yes, final decree proceedings because
What is the suit for?
Suit for it's a earlier the court has already declared the rights of parties. So far as my party right has been declared to an extent of I am the owner of 7/12 share, and there is an interim order, there is an injunction order, final permanent injunction order restraining these persons till I was put in position of my 7/12 share. Or if I
let me please draw the
yes,
attention of the court to that order.
yes. Will ask me kindly take annexure 6, annexure C, page, typed copy I will refer.
Yes.
Page 81,
Yes.
In the earlier suit, they have been declared as they are entitled for 1/12 share, 1/3 share. In this case, I filed
The suit for declaration.
Yes, suit for declaration. Issue number 3, Lashma, kindly see.
Yes.
The suit in OS number 8, OS 484 of 82 was originally filed before the
No, the issue is whether the defendants prove the sale lead.
Yes, ma'am. Page 18, para 18, page 82, Lashma, kindly see. Therefore, I am of the opinion that plaintiff number 1 must be permitted to enjoy the entire plain schedule property till the conclusion of proceedings in OS 484 of 82, and he is put in possession of his separate share or till dependent 3 and 4 are put in.
I'm not able to see. Where are you reading?
Page 82,
82.
and para 18.
Please read.
Para 18. In that from 6, 7, 8 line onwards.
I'm of the opinion.
Therefore, I am of the opinion that plaintiff number 1 is this petitioner herein. Plaintiff number 1 must be permitted to enjoy the entire plain schedule property till the conclusion of the proceedings in OS 484 of 82, and he is put in possession of his separate share or till defendant 3 and 4 are put in possession of their separate share. The plaintiff 1 should also be directed not to damage the plain schedule property or put up any construction, so and so. And now,
no, 1 minute. This is OS number
199.
196.
196 of 1999.
Which is decreed on?
Decreed on 13th April 2004.
13th April 2004.
Yes. Now, in reference
till the conclusion of the proceedings in OS number 480, OS number 482 of 80.
Yes, that will I will find it annexure B, page. This is suit for partition. This was filed by the respondents against my vendor and others. Against by my vendors and others.
Your vendor was a
party in that, defendant.
In the OS number 196 of 1999, your vendor was arrayed as?
My vendor was not a party in that suit. I am a plaintiff in this.
Come to the
184.
In 196.
196. Page
68.
Yes. In that Bedur Mallappa is plaintiff. In his favor, the decree has been made.
What is the connection between Bedur Mallappa and your vendor?
Bedur Mallappa is my party. My vendor is, in this case, OS 482.
No. OS number 196 is a suit for declaration.
Yes, ma'am.
Filed by whom?
Filed by me.
Filed by you.
Yes, ma'am.
So in that, there was a direction that plaintiff number 1 must be permitted to enjoy the entire plain scheduled property
Yes, ma'am.
till the conclusion of the proceedings in OS number 482 of 82.
Yes.
Oh.
Yes, ma'am.
No, 482 of 82 is filed by?
Filed by the respondents herein, ma'am.
Not herein, therein. In your suit, they are not the parties.
They are parties, ma'am.
No,
In my
they-
suit also they are parties.
That's what I'm saying. They're arrayed as a defendant number what? That
A
I'm
defendant,
also-
my lord, yes, ma'am. Yes. Sorry, ma'am. They are, my lord, defendants 3 and 4, my lord. Sabjan Saab and Masjid Saab.
3 and 4.
Yes, ma'am. 3 and 4. In this case also, Ilash, may kindly see. ma'am. They are
So,
claim.
no, the issue is like this. You filed a suit for declaration and you are not a family member.
I'm not a fan.
So then.
I'm the purchaser.
So against your vendor, they filed a suit for partition.
Yes, ma'am.
So in this suit, the court said because you are in possession of the property,
Yes, ma'am.
you enjoy the
Not
property.
in this suit, my lord. In the earlier suit, 484
No,
of
not
82.
484. This is 196 I'm referring.
This is this is a suit filed by the purchaser. My vendor was a party in the earlier suit against the very same person.
I asked you, suit number.
Blood, I will clarify, my lord, your lordship's doubt, please. Adike, idನ್ನ ಈ last may kindly take this, my lord. OS number, my lord, annexure B, page 23, so that your lordship's doubt will be clear.
23.
Yes, page 23, annexure B. Ilash, may kindly see, my lord, in this case.
24 of 82.
Yes, ma'am. Plaintiff in this case is elected to Aziz Saab. Elected to Aziz Saab, the defendant 3 and 4, what I referred, they are the legal heirs of elected to Aziz Saab. And my party in this case is defendant number 1, Venkat Narayanappa. Ilash, may kindly see the order, operative portion of the order.
So now this is a suit for OS for 480.
Partition. This is a suit for partition.
Purchaser from whom?
Defendant number 1 in this suit.
No, Venkat
Narayanappa.
Purchase the property from whom?
He purchased the property from one Fatima B. So Fatima B and elected to Aziz Saab, they are the members.
Of the joint family?
Yes, they are members.
You have purchased from Venkat Narayanappa.
Venkat Narayanappa, I purchased.
What happened to this suit?
So in this suit, Ilash, may kindly take page 47. Para 22.
Yes.
The plaintiff has proved that he acquired 1/3 share in the suit property under the sale deed dated so and so, executed by PW 1 and 2 in his favor. The first defendant is my vendor, my lord. The first defendant has failed to prove that he acquired title to the entire suit property exhibit D1, but he has acquired only 7/12 share of deceased Dastgir Saab. So in this suit, I have been declared as 7/12 share. The other party is.
Your vendor is declared.
Yes, ma'am.
7/12.
7/12 share.
This is decreed when?
This is decreed, my lord, on 25th March 1985.
When did you purchase?
My lord, I purchased, my lord, in the year 1971 itself. I purchased from the very same person, Venkat Narayanappa. He purchased.
You were not a party.
I am not a party in this suit. That's why, my lord, I filed a separate suit. 196 of 1990.
196 of 99.
Yes.
Then why the court is saying subject to the result of 484?
In this, my lord, this is a partition suit. Proceedings will be ended only after final decree and putting the parties in possession of the property. With that intention, my lord, there is an observation in this suit. Subsequent.
How is it beneficial to you? The court has not determined your right with regard to the property. Court simply said you can enjoy the property till the final decree proceedings conclude in that 484 of 82.
No, I have been declared as I am the person entitled for 7/12 share in the property. That is the observation, my lord. That's the findings also has been recorded. My sale deed has been recorded, and in the previous suit, whatever the proceedings and findings that also has been
Where is
discussed.
that finding?
That's why page 8, paragraph 18, you'll ask me kindly see.
The plaintiff number 1 has no absolute right over the plain scheduled property. The order regarding future mean profits is already ordered to be taken.
Yes.
So,
Therefore, I am of the opinion that plaintiff number 1 must be permitted to enjoy the entire plain schedule property till the conclusion of proceedings in so and so, and he is put in possession of his separate share, or till defendant number 3 and 4 are put in possession of their separate share. The plaintiff number 1 should also be directed not to damage the plain schedule property.
No.
What is the extent? You'll ask me kindly see the operative portion. The suit of the first plaintiff with respect to prayer of declaration of his title over the plain schedule property is dismissed. The defendants or and persons claiming through or under them restrained by way of permanent injunction from interfering with the position of the first plaintiff over the plain schedule property in any manner till the conclusion of proceedings in OS number 484, until first plaintiff is put in possession of 7/12 share, or till the
I want you to show the court, where is this 7/12 share granted to you in this judgment?
This is the plaintiff is put in possession of his 7/12 share, or till, this is the
There should
observation.
be a finding first, then that's a conclusion.
Yes, my lord.
So now, your vendor is a party to that proceeding.
Yes, my lord.
He was given 7/12 share.
7/12.
So how you are entitled for that 7/12 share?
I being the purchaser of that property.
Where is that finding?
Yes, my lord. I will take your lordship.
I hold that the plaintiff number 1 has failed to prove that he is absolute owner of the plain
The
scheduled
entire property.
But it doesn't mention about anything. But he has proved that he is in possession of the plain scheduled property. That is the finding at page number 80.
And the very first
On issue
sentence
number
is,
1.
the suit of first plaintiff is decreed in part with no order as to cause. This is the sentence, beginning order. First order, Ilashmi kindly see. The suit of the first plaintiff is decreed in part with no order as to cost. Because my lord, in this suit, I asked for declaration that I am the owner of the entire property. The court, considering the previous judgment and my lord, the findings that has been recorded against my vendor, the court comes.
One thing is,
Yes.
just because your vendor, when you have purchased a property from the vendor.
Yes.
And your vendor is a party to the earlier proceedings.
Yes.
Just like that, you will be entitled to his share without a declaration or without you.
My lord, here the declaration, this is a declaratory suit.
That
What?
I'm not able to- Court only says you are in possession of the property.
Yes.
Court has left it to the pending final decree proceedings. Court has not decided anything with regard to your title. Court only recorded that you are in possession of the property. That
I
is
am
what
in
the court
possession of the
understands.
property by virtue of the sale deed. my lord. That I will refer.
Court only said, court has not declared anything. By virtue of this, court said, you are in possession of the property. Now, you will be continuing in that possession till that final, subject to the final decree proceedings. That's what is the order. Not that court has not
No,
declared
my lord.
anything.
Because in the entire body of the judgment that has been discussed in detail and finding has been recorded
Show
that
me one line where the court said, the owner, the vendor of so-and-so he has purchased a property from so-and-so. He has been granted 7/12 share or whatever.
Yes.
And as he being a purchaser,
Yes.
no, he's entitled for that. And
Yes,
his-
that I will.
His right to the property is declared as
Yes.
far as 7/12 share is concerned.
Yes.
That you please show.
Yes, my lord, I will. Page 74 are the issues that were framed against. Yes, please. 74.
Yes, let's see.
Whether plaintiff proves that plaintiff is the absolute owner in possession and
So,
enjoyment of the suit schedule
On
property.
issue number 1,
Yes.
the finding is at page number 80.
Issue number 1, page 76. my lord.
No, 80 is the observation. What is the finding on 80? Before issue number 2.
Yes, please.
I hold that the plaintiff number one has failed to prove that he is the absolute owner of
No,
the.
you'll ask me kindly read from para 13 onwards, so
13,
that
yes.
the entire thing that has been
Please read,
discussed.
please read.
The plaintiff number one stated that he acquired the plain schedule property under exhibit P1 at the registered sale deed executed by defendant number one and two, along with their minor children. The defendant number 3 and 4 have stated that defendant 1 and 2 have no full right over the plain schedule property. Therefore, there was a burden on the plaintiff number 1 to show how his vendors acquired the plain schedule property. But the plaintiff number 1 has not produced any registered document to show that as to how his vendors acquired the plain schedule property. In his cross-examination, PW1 has stated that his vendors purchased the plain schedule property from Dasgir Saab, Fatima B and Amir Saab. He has admitted that the plain schedule property was purchased by either B and Dasgir Saab in the year 1937. He has denied that the children of either B have sold either be off share in the plain schedule property to Telecast Aziz Saab, the father of defendant number 3 and 4. The defendant number 3 and 4 have contended that their father had filed suit in OS 484 of 82 against defendant number 2 and others. In that suit, it was held that defendant number 2 has acquired only 7/12 share of deceased Dasgir Saab under the sale deed dated 9/2/71 in exhibit P1. The sale deed in favor of plaintiff number 1, there is a reference that defendant number 2 acquired the plain schedule property under the sale deed dated 9/2/71. The defendant 3 and 4 have produced the judgment and decree in RA number so and so, preferred by defendant number 2 in this suit against the judgment and decree in OS 484 of 82, and it shows that the said appeal is dismissed. It is also held that father of defendant 3 and 4 has 1/3 right in the plain schedule property. The findings in the suit OS 484 of 82 also bind the plaintiff number 1 in this case, as it is already held in OS number 484 of 82 that the vendors of plaintiff number 1 has only 7/12 right in the plain schedule property, and the said findings is confirmed in the regular appeal, and the plaintiff number 1 has not produced any material to show that any regular second appeal is preferred by his vendor. The said findings operates as res judicata, therefore it cannot.
I've seen the entire one, even
Yes.
the order also.
Yes.
The suit of the first plaintiff with respect to the prayer of declaration of his title or the suit property is dismissed.
Allah, it is decreed in part.
Decreed in part.
Decreed in part to the extent.
I'm reading from the order at page 83.
Yes, madam.
The suit of the first plaintiff is decreed in part. What is decreed in part? Is the
Decreed
next
in-
one.
Decreed
With regard
in
to your possession as far as the
Allah,
property.
decreed in part to the extent that the property is entitled for entitled for 7/12 share.
That's not the order.
7/12 share.
The suit of the first plaintiff is decreed in part with no order as to cause. Then what follows? The suit of the first plaintiff with respect to the prayer of declaration of his title or the property. If what you are saying is correct, the court could have said, as far as 7/12 share is concerned, the suit is partly decreed. Court says now, court recognizes your possession, and that is subject to, you can be in possession of the property, subject to the final decree proceedings is what the court said.
It is further said whether I should be
Still,
put in,
That
whether
will
I
be
should,
decided. That will
I
be
should be
decided.
put in possession of 7/12 share in the property, or the respondent 3 and 4 shall be put in possession of 1/3 share. Till such time, I can enjoy the entire property, the injunction that has been granted.
That is subject to the result of OS number 482 of 82.
That suit is already decided.
Final decree proceeding.
Final decree proceedings are pending.
Now I understood the facts of it. Please come.
In that, I am filed an application seeking impediment to say that I am also a necessary party to this extent, because a right has been given to me to an extent of 7/12 share. I am entitled to possession of that, and the plaintiffs are entitled for possession of 1/. Ilashma, kindly take this matter by tomorrow. There is an appellate court judgment also there. I will produce that. That will clear.
We'll see the impugned order.
Yes, madam. Impugned order.
Page number.
Page 104 Ilash 103, it starts reasoning portion. And Ilash kindly.
Yes. From the beginning, you can read it. It's a
Yes.
short, small order.
Admittedly, the Ellicott Aziz Saab had filed a suit for declaration and separate portion of his share over the suit schedule property, and said suit came to be decreed. The contentions raised by the applicant is that he is the absolute owner and in possession of the suit schedule property. It is further case of applicant is that he had filed OS 199 of 1999 in the judgment and decree passed in OS 484 of 82. It is ordered that plaintiff is having 1/3 share in the suit schedule property. Further ordered that first defendant has failed to prove that he acquired title to the entire suit schedule property under Exhibit D1. The first defendant is none other than the vendor of the applicant. When the applicant's vendor has not authority over the suit schedule property, consequently, the applicant has not at all hold any right and possession over the portion of scheduled property. The applicant himself had filed OS 196 of 1999 against Srinivas Murthy and others for the relief of declaration of title and consequential relief of permanent injunction.
Srinivas Murthy.
He is also one of the defendants.
You have not impeded your owner.
Srinivas, he is also there. His LRs has been, he died. That's why his LRs have been brought on record in that suit and also before this honorable court.
Yes, yes.
The applicant himself had filed OS 196 of 90 against the Srinivas Murthy and others for the relief of declaration of title and consequential relief of permanent injunction. The said suit came to be partly decreed. In the said suit, the title of the plaintiff is dismissed and granted injunction by stating that the defendants or any person claiming through or under them are restrained by way of permanent injunction from interfering with the portion of first plaintiff over the plain schedule property in any manner till the conclusion of proceedings in OS number 484 of 1982, until the first plaintiff is put in possession of 7/12 share or till defendants 3 and 4 put in possession of their separate share in the plain schedule property. In order to put the respective parties in possession in final decree proceedings, I am a necessary party. Only to that extent my application was filed. That application has been rejected.
If your rights have to be determined,
Yes.
you should have included all those parties.
All of them are
were
parties.
there in the, but unfortunately, court has not given any finding with regard to your share. That is
The
what.
court- The court, when court categorically says that I should be put in possession of my 7/12
Still,
share.
it is not a
Till
positive order.
permanent injunction for the entire property.
It said you will entire.
I can enjoy the entire property till conclusion.
That doesn't mean that it's a positive direction. Suit, in a civil suit, the decree should clearly contain what is that the court said. That doesn't, what the court said, because 484 is pending before the final decree proceedings, your vendor and all are the parties to that. Whatever that happens, and if you are put in
this
possession of
process, in
7
this
by
process,
17th share, because if you had a court, there should have been a declaration that you are the owner of 7/12 of the share, because it's a suit for declaration. Your possession is protected.
position. And my share also has been categorically stated.
You said you want to place something, place it, but the court is not convinced. Let's this matter on Friday. Yes, next.
Number 32.
No representation for the respondent, heard the counsel in part. Yes, next.
Number 32. Badrinath R. For petitioner.
And I represent.
M. Shiva Prakash.
I pay for petition.
Yes.
The respondent he didn't file a suit for strict work permit.
Hmm.
His suit came to be decreed.
Hmm.
I had preferred an appeal. Appeal came to be dismissed.
Dismissed.
Yes.
Hmm.
Whereas respondent he didn't file the execution petition. During the pendency of the execution, I had filed an application, section 28 of the Specific Relief Act, for rescission of the contract. That application.
The contract.
That application came to be rejected.
Why should be resigned?
Where the decree passed by the court, passed by the trial court, may kindly look into typed page annexure B.
Page number.
Page number 83, operative question.
Yes.
The suit of the plaintiff in OS number 2682 of 92 is decreed with cost as prayed for. The first and second defendant are hereby directed to execute the registered sale deed in terms of the agreement dated 2/6/1989 in favor of the plaintiff within 30 days from the date of this order. If the defendant fails to execute the registered sale deed within 30 days, plaintiff is directed to get the sale deed through the
This order
order.
is dated
Order is dated on 30th
30th
November 1998.
when is the EP filed?
EP filed in the year 2006.
2006.
2006.
Appeal is filed, RA.
Execution petition.
You preferred RA. When is the RA disposed of?
RA disposed on 13/7/2005.
Yes, and then in 2006 he filed.
Yeah.
Now let's go, please come to the impugned order. Page number.
Kindly look into annexure. See page number 104.
104?
Applied court judgment.
Yes.
Page number 110. Para number 11.
Yes.
Defendant 2 of this suit had also been filed another suit against the plaintiff with the respondent number 1, seeking declaration of title and the suit property with consequent relief of injunction on the basis of the alleged sale deed executed by the defendant 1 in favor of defendant 1 in her favor. Both the suits were tried together by the learned trial judge were disposed of simultaneously when the suit filed by the defendant 2 J. Shantamma in West number 2896 that has been dismissed by the learned trial judge on the defendant 2, and J. Shantamma has not preferred any appeal against the said judgment, and the decree has been reached finality. The render in the above circumstances, in view of the evidence available on the record, the learned trial judge has rightly held that the plaintiff respondent has proved that the first defendant appellant has executed the agreement of sale exhibit P1 in favor of the in respect of the suit property on 15/6/1988 by receiving a 25,000 rupees towards the part payment consideration amount. Therefore, the appellant is under a legal obligation to execute the sale deed in favor of the plaintiff respondent 1 by receiving the balance sale consideration amount of rupees 5,000.
Yes.
I find no perversity or capricious or illegality in the following findings given by the conclusion reached by the trial judge. There is no ground on made out in the interference with the impugned order and judgment decree by this court. Therefore, in the result, I pass the procedure. The appeal is dismissed. May I kindly look into them? Annexure J typed page 156.
Yes.
Upon hearing the arguments on both the sides, there is no dispute as to passing of the decree in OS number 268
You're
of
reading what?
What?
You're reading?
156 page number.
Appellate court judgment.
No, trial court judgment where the execution decree which I am is challenged.
What is the relevancy of?
Where it has been my application came to be rejected.
No, that order is in 144, I think, 143. That's the impugned order, not?
Impugned order. It's a typed page.
I'm looking at that. The typed one.
156.
140, it started somewhere around 141.
Yes.
That we will read.
Yeah. 147.
Yes.
Typed copy also filed, but it's
No.
it's legible. 150.
Typed copy legible is. Page 156.
147. No?
The same typed page, 156.
150?
6. 156.
We'll look at it, no problem. 156.
6.
Read.
Upon hearing the arguments on both the sides, there is no dispute as to passing of the decree in OS number 268 of 1992, dated 30/11/98, and also with respect to the regular appeal filed by the JDR in RA number 24 of 99.
it is the contention of the JDR that the DHR has not deposited the balance sale consideration even after dismissal of the appeal by the first appellate court. And even after expiry of the appeal period to the second appellate court, and the DHR has filed the execution petition on 23/2006 without depositing the balance sale consideration amount. And also the decree is silent about the amount time limit within which the plaintiff has to deposit the balance sale consideration amount as per section 28 of the Specific Relief Act. The execution petition is liable to be dismissed. In this contention, DHR that the contents of the suit in OS number came to be
Yes, sir.
declared and even
Yes, sir.
only I'll lay on one judgment, two judgments on.
Pass on.
Under similar circumstances, where the amount has been, where in this case, where the ex parte order is passed.
Yes.
Where in my case, both the parties have been heard and order has been passed. Where the trial court has passed an order, amount is not remaining, balance sale consideration has to be deferred, it has been not specified in the operative portion of the judgment. Where the first appellate court comes to conclusion, in the, before the operative portion of the order, amount is due, 5,000 rupees is due is there. Being no,
What is the consideration?
Madam?
How much is the consideration?
but total sale consideration is 30,000.
Hmm.
25,000 has been paid, 5,000 still is due.
Yes.
Well, in his objections also, he has filed an objections, he is ready to deposit the amount when and where the court insisted. Where in the operative portion of the decree, there is no specific order for depositing of the amount and the time. Under such circumstances, where this honorable court comes in.
Para number.
Right. Para number 22.
Yes, please read.
Skip up the 2023.
Yes.
If the defendant was a default, he was not willing to obey the decree. The plaintiff had deposited the money after the expiry of the appeal period as stipulated in the decree, or at least at the day under the execution of the petition. What would have to be sufficient to demonstrate is two bona fides. The balance sale consideration is 2,85,000 had to be deposited on the date of the suit or on the date of the decree or at least date on filing of the execution petition. But the plaintiff, the decree holder, appears to have been waked up after seeing the awareness in IA number under section 28 of the Act, made the application in the mind to deposit the money only on 14/7/2001, which is merely 8 years after passing of the decree and 14 years after from the date of the agreement. The subject matter of the suit is not a immovable property stipulated in the tiptoe town. The value of the immovable property situated towards the citations of the multiplicity of every year. The plaintiff decree holder who had benefit of the decree has also had the benefit of having 2,85,000 with him. After 14 years, and he did not even seek extension of time to deposit the said amount. Today, if the courts were to be directed to defendant judgment departed to execute the sale deed for the said consideration, he should have been received the 14 years ago itself. It would have become greater hardship to the irreparable loss as if the said amount would be no value at all. In that view of the matter, the contract of sale requires to be rescinded. Consequently, the degree of specific performance also requires to be annulled. We are the contract of rescission under subsection 1 of section 28 of the Act. If the justice of the case is to be required, the court can be provided under section 28(2)(b) of the Act for refund of the any sum paid by the vendor or lessee or earnest money or deposited in the connection with the contract or similar to section 65 of the Contract Act, and also to cost of the obligation upon the person to whom he received the advantage under which the agreement or contract had become void, to rescind the contract to make in permission the position of the property from whom the received. Therefore, the defendant judgment departure shall refund the advantage of the earnest money or receive the amount the plaintiff decree holder under the agreement if that is a sum of rupees 1,75,000 together with interest at 18% per annum from the date of rescission of the amount till the date of the payment. If he wants to rescission of the contract, in the result, I pass the following. The contract has been rescinded.
What is the other judgment?
Yeah.
They got it.
Para number 24. Where he had filed an application under section 148 of the extension of time, where in my case, no application is filed, no amount is deposited within time. Only that is there.
Yes.
24 and 25. Shall I read 26?
Yes.
In the above and for the reasons stated above, both these appeals are succeed. The impugned common judgment and order of the dated so passed by the court will dismissing the revision petition from the common judgment passed by the OSM so on. So the plaintiff seeking extension of time without a huge delay of 853 days and dismissing the IAN also by defendant rescission of the agreement to sell dated so are hereby quashed and set aside. And IAN also filed by section 48 of CPC and section 28 of the specific seeking extension of time within the huge delay of 853 days in depositing the balance sale consideration stands dismissed. IA number so and so filed by the appellant defendant under section 20 of specific effect to rescind the agreement to sell dated 9/5/2012 a non-payment of amount deposited the balance sale consideration. The plaintiff, which is the plaintiff, to required to deposit the pay within a period of 2 weeks from the date of ex parte judgment and decree dated 12/10/2003 stands allowed. The agreement to sell dated 9/5/2012 stands rescinded in exercise of the powers under section 28 of the Specific Relief Act. However, the appellant herein is directed to refund the amount 8 lakhs together to the plaintiff with interest, 12% interest from the date of 9/5/2012 till actual payment within a period of 6 weeks from today. Well, it shall carry a interest at the rate of 18% per annum.
We'll ask.
One more. Only one copy which I have, I'll lay only one. Which I'll 2017-11. 2017-11 SCSC 57.
Yes. Which para?
Para number 8 and 9. I'll furnish.
It's there.
No.
It is there in the record.
Prem Jeevan's case. Give him that copy. Para number?
Para number 8 and 9.
Yes.
Reference to Order 20 Rule 12A of CPC shows that even if the degree of specific performance of a contract, the court has to specifically the period of within which the payment has to be made. In the present case, said period was 2 months from the date of the decree. In the absence of any said being extended, the decree holder could have to execute the decree only by making the payment to the decretal amount to the judgment departure or making a deposit of the amount within the terms of the decree. In present case, neither the said deposit was made within the stipulated time or extension of time was sought or granted only to the explanation to begin but furnish the delay in making the granted for deposit explanation of the amount extension earlier to the counsel which the decree has to be relying upon amount. The judgment on renewal so and so. In appropriate case, the court has which passes the decree would extend the even evasion of the Specific Relief Act. In the present case, no such steps have been taken by the decree holder. In these circumstances, the contention advanced by on behalf of the decree holder, the respondent herein, unless to judgment departure seeking rescission of the contract in terms of section 28 of Specific Relief Act, the decree remains executable in spite of expiry of the period for the deposit, which only the obligation for the part of the decree holder to pay the interest cannot be accepted. Section 28 of the Specific Relief Act, so rescission section 28 has been extracted.
I've gone through the judgment. Yes. Mr. Counsel.
Now, the suit of the plaintiff is for specific purpose. Suit is of the year 1989 agreement, and the suit is filed in the year 1989.
Decreed on 30/11/1998.
The decree was on 30/11/1998, my lord. And again,
Decreed appeal was dismissed on
13/7/2005.
You filed the EP on 23/2006.
23/2006.
No, by the time you filed the EP, have you deposited the amount?
My lord, I did not deposit the amount is
Why?
one aspect. Because this decree is passed against two persons, because he has already sold the property to some person. Against him also, the decree is passed nullifying that sale deed. That's one aspect. Number two is both the plaintiff, she, that is Shardama, she passed away. Date I will furnish it during pendency of the appeal. And soon after passing of the decree in appeal, her husband also passed away. LRs are brought on record. And I filed this execution in the year 2006. 2006, the notice has been served on the respondent judgment letter in the year 2006 itself. Then from 2006 onwards, up till 2014, on one or the other reasons, the matter has been dragged on by this JDR. In the year 2014, that's 2006 to 14, almost 6 plus 2 is 8 years. After, in the year 2014, my lord, on 24/11/2014, 3 applications are filed. Out of 3 applications, 2 applications has been rejected by the humble trial court. And 1 application is under 28 to rescind the contract.
Even till now, you deposited the amount?
My lord,
Even till now?
in my objection, I said that I am prepared to.
Prepared to? Who will tell you to?
My lord, the reason is, as we can understand, section 28, may I kindly take my lord to section 28?
No, before going to section 28, you have a decree in your favor.
Please, my lord.
His appeal is dismissed. You filed an execution petition. Though the decree is silent about when the amount has to be paid.
Correct.
When you are seeking execution, by that time, you should pay the amount and seek for execution. That's your part of that's your
Obligation.
duty to do it, your obligation. That you have not done it. Even till today, filing a petition saying that I am ready, why will the court ask you to pay?
No, I am ready in the sense, orally I made my submission. That's what, because one after the other
Till now, nobody can stop you from paying the money. Why have you not paid? Till today.
That's one aspect. I can pay it, my lord. I can pay it.
Pay it.
One aspect. That's one aspect. And the second aspect is, my lord, in the similar circumstances where the decree passed in specific performance is a preliminary decree. Now in the execution, what is the power conferred on the execution court, and what is the law on that point is only way back in the 1980 itself. The humble apex court, then Justice Krishna Iyer has declared it, and because the circumstance, one after the other, these plaintiff, Srimati Shardama, she passed away during pendency of the appeal. And
when a person passed away and you can file an execution petition for seeking execution.
their LRs are brought on record.
LRs can file the money, has to deposit the money.
LRs have to deposit. That's one aspect.
No, when you are not depositing, application has been filed for extension of time. That you kept quiet. Even till now, you don't deposit the money. When the RA is dismissed on 13/7/2005, we are in 2024.
2024, my lord.
25,
No.
all the more reason.
One thing which, whether such application is filed and whether such statement is made by the learned advocate who is appearing in the trial court, I can get information, I can make my submission is one aspect. Second aspect is, may I kindly take my lord to the one decision which.
Yes,
the Yes. I'll furnish one copy. 1980, one Supreme Court case was 630. My lord, first I will take head note and para 4, I will take my lord to straight to the para 4. my lord, in the head note is section 28, where in a suit for specific performance of an agreement to sell, a court has directed plaintiff to deposit in court. Held proper procedure would be to pass decree for specific performance, which would be in the nature of preliminary decree. Suit would continue and to be under court's control until either party moves for passing final decree. Held further that the such court has power under section 28 to extend time for making deposit. But since the specific performance is an equitable relief, it can impose equitable terms while granting relief to the plaintiff equity. Section is the para 4, my lord.
Yes.
It's the Lordship Krishna's judgment. The language also in the same para 4. It is perfectly open to the court in control of the suit for specific performance to extend the time for deposit. And this court may do so even now to enable the plaintiff to get the advantage of the agreement to sell in her favor. The disentitling circumstance relief relied upon by the defendant respondent are offset by the false plea raised in the course of the suit by him and rightly negative. Nor are we convinced that the application for consideration and extension of time cannot be read as in substance. It is a petition for more time to deposit. Even so, specific performance is an equitable relief, and he who seeks equity can be put to in terms to ensure that the equity is done to the opposite party even while granting the relief. The final end of law is justice, and so the means to it too should be informed by equity. That is why he who seeks equity shall do equity. Here, the assignment of the mortgage is not valueless discharge of the vendor's debt as implied in the agreement to sell, but disingenuous disguise to arm himself with a mortgage decree to swallow up the property in case the specific performance litigation decree to performance misfires. To sterilize this decree is necessary equity to which the appellate must submit herself before she can enjoy the fruits of the specific performance. In the present case, with all that has been said by both sides, and we have heard a great length arguments by so and so. It is clear that an opportunity for appellant to deposit into the court the amount directed by the trial court, together with interest drawn down to date at 11% should be accorded. We are not discussing the principles of law as they are well settled and do not require reiteration. The equitable terms we have adverted to earlier must be remembered in this context. The appellant who was bound to discharge the mortgage acted contrary to the agreement because instead of paying the mortgage amount and extinguishing the mortgage, which was perhaps a pardonable exercise in lieu of the deposit into the court, she, under some ill advice, took an assignment of the equitable mortgage with a view in using it against the respondents. Surely, this was not consistent with the understanding assumed under the contract. This justifies the view of the High Court that as a price for the indulgence of being allowed to deposit along after a due date was over, the unrighteous advantage gained by taking an assignment of the mortgage should be nullified. In brief, while the appellant may be allowed to deposit the amount due under the agreement dated so agreement, namely so and so, together with interest at 11% from April 67 up to so and so. My humble and respectful submission and appeal before my lord, the suit for is equitable relief where a substantial amount of 25,000 is paid as on the date, and the way in which they have harassed and the way in which they have humiliated, finally even the fruits of that litigation, the lady who filed Shardama, a old lady, she passed away, and also her husband passed away, and LRs have come on record. They have come on record. The original plaintiff, she could not reap the fruits of the litigation. The way in which this litigious defendant or litigious JDR have caused to say prolonged and caused so much of humiliation, harassment to the maximum extent. Now, ultimately, this is the stage where the court has to proceed for execution of the sale deed. At the time also, after 8 years, they have filed this petition. The conduct of the party also should be looked into. So far as me is concerned, that 5,000 to be deposited or to deposit before the court. I can with, because I am only on the equities in the decree also. I can seek permission. Also, I can make necessary application.
You cannot seek permission now after how many years? 20 years.
My lord, we have to take into consideration from the date of execution 2006.
That's what I'm
2006.
No,
And
2005.
my lord,
2005 is the decree.
decree is, but
The RA is dismissed. EP filed in 2006.
But-
So it is after 19 years. 19 years delay cannot be condoned for seeking extension of time for depositing the amount. That too after a petition under
no,
28 is already
in
filed.
similar circumstances, this court, division bench court, they have extended and it has been departed.
Any application.
No, I can make an apply the
Petition after 20 years.
20 years, 20 years.
After a petition under 28 is filed.
Yes.
Please show
I
the
can,
document.
Justice, the Lordship Justice Sujata and Emma Arun, I can place it on record tomorrow itself.
Place it, but
I-
I'm not convinced. I'm indicating my mind.
And
Tomorrow,
the-
Carter,
my lord, and tomorrow, the second thing is, now as it is, we have to go by the intention of the legislatures, one thing, which I would like to take little more time, my lord. The section 28, I will read and reread it, my lord.
yes.
My lord, rescission in certain circumstances of the contract for sale or lease of immovable property, specific performance of which has been decreed. Where in any suit, a decree for specific performance of a contract for the sale or lease of immovable property has been made and the purchaser or lessee does not, within the period allowed by the decree or such further period as the court may allow, pay the purchaser money or other sum which the court has ordered him to pay, The vendor or the lessor may apply in the same suit in which the decree is made to have the contract rescinded. And on such application, the court may, by order, rescind the contract either so as to, so far as regards the party in default or altogether as the justice of the case may require. Subclass 2. My lord, in the first section 28, its intention of the legislation is so clear. Where there is a specific period is given and a specific time is given, there, if any default is committed, then they can invoke this 28. That's what, those lines again, I would reread it, my lord.
I have read it. I read
Yes,
it, I read it.
that's the, where a specific decree, where passing of decree. Now we are in the continuation of the decree where the court, humble court specifies the date or conditions that should be fulfilled, that's the obligation.
Relying on Justice Krishnayar's judgment.
My lord,
Krishnayar has, what you have read it, he said that a person who seeks equity should do equity.
correct, my lord.
So whether the court, what is the intention of the legislature when you want an execution of the decree, by the time you should pay the amount and ask the court to execute the decree,
My lord,
the sale deed.
one thing is now the court while passing decree, whether advertently, inadvertently, I think,
Still, it can't be an inordinate delay of this much.
my lord, the
Have understand, even as on that day of filing of the EP, you have not deposited the amount, but at a subsequent period, he wanted to deposit, court has not accepted, or you have sought for time. Any of these things have happened, court can at least consider looking that angle of equity, but this is not.
that's one aspect. And second aspect is because of the intervening death of these persons.
When you can file execution.
Execution by his.
The death,
Now,
why
after,
can't you file pay the money also?
my lord, first is the lady Shardama passed away. Then in the appeal period, husband was alive. Husband during Corona period, he passed away.
Execution is filed when?
By Shantama itself.
By the?
Shantam, by LRs. No, mother itself had been filed. Thereafter, the legal aids came on the record.
Anyhow, you get those, whatever you
That
want. the
one
judge-
decision where in the similar circumstance where the court has extended time,
For division by judgment, please get it.
I will place it on record, my lord.
More as part heard the councils in part, listed as part tomorrow. Yes, next.
Cell number 33, K. Abhinav Ranan for petitioner, P. Sharat Kumar.
Well, Lord, I am for the defendants petitioners.
Where are the respond, you appear? Yes. Yes.
Lord, suit for bare injunction, IA1 for temporary injunction was filed.
Hmm.
It was allowed and temporary injunction was granted,
Hmm.
against which miscellaneous appeal was preferred.
Hmm.
And that also came to be dismissed through the judgment dated 18/11/2017.
Again, is that you before this court?
So the defendants are more filed this
Yes,
writ petition,
yes.
agreed with both the orders, judgment and order of the courts below. My
Let's
lord,
see
the
courts.
subject matter of this suit, my lord, is 3 acres 16 guntas of agriculture land in survey number 112 of Kastur village, Sante Maralli Hobli, Chamaraj Nagar Taluk district. So, my lord, the plaint, your lordship may kindly go to page 65.
What we'll do is, first we'll go to the impugned order, then you can make your submissions.
Please, my lords.
We'll go to the appellate court's order.
Please. My lord, appellate court has come to the conclusion that the trial court's order does not require for interference, and consequently the appeal has been dismissed.
Let's read from page 31,
Please, my lord.
point number, the reasoning part.
Please, my lord. Para 14, my lord.
Yes.
It is a specific case of the plaintiffs that their father was mortgaged the suit's property to father of the defendants on 23/361 through a registered mortgage deed. But the physical possession of suit property was not handed over to father of the defendants by name Chamaya, and thereafter mortgage amount was received by said Chamaya from their father, and both were agreed to discharge Shara of the mortgage deed before the sub-registrar. The defendants have not disputed the mortgage deed dated 23/361, but they contend that the physical possession was handed over to their father on the date of mortgage, and till now the said mortgage is not redeemed. The mortgage period is 2 years. The plaintiffs or their father has not come forward to pay the mortgage amount after completion of mortgage period to redeem the said mortgage, and after lapse of 30 years from the date of completion of mortgage period, the plaintiffs have lost their right over the suit property as per Article 61A of the Limitation Act. It is well settled that at the time of disposing of the application for temporary injunction relief, the court has to consider prima facie case and also balance of convenience. Admittedly, mortgage deed was executed by the father of the plaintiff in favor of the father of defendants on 23/361, but both parties have not produced original mortgage deed. They have produced only certified copy of the same. On perusal of the certified copy of the mortgage deed dated 23/361, it is usufructuary mortgage, and it was made for 2 years or till payment of mortgage amount. In the said mortgage deed, there is a recital that the mortgagee has to pay the taxes to the government time to time. But the defendants have not produced any document to show that they are regularly paying taxes to the government since the date of mortgage till this date. Per contra, the plaintiffs have produced tax-paid receipts. The plaintiffs have produced the receipt, record of rights, and copy of MR number 1 of 1994. As per MR 1 of 1994, the Kata has been changed in name of plaintiffs and their brother and the death of their father on 23/12/93. It is pertinent to note that as per copy of the said mutation register, before changing the Kata, there was a publication in the village, and after 30 days, Kata has been transferred in favor of plaintiffs on Subramania. As per record of rights from 66/67 till now, the name of the plaintiffs and their father Subramania entered the column number 9 and 12 of the RTC. It is pertinent to note that no name of mortgagee has been entered in column number 11 or 12 of the record of rights pertaining to the year 66/67 till 2013-14. But as per record of rights, 24/12/14, The name of Chamaya entered in column number 11 of RTC as per order passed in RRT number 783/1314 as mortgage for rupees 300. It shows that the father of the defendants or defendants have not taken any steps to enter their name in the record of rights till RRT proceedings. Moreover, they have not objected the transfer of Kata and favor plaintiffs in the year 93-94. Admittedly, as per Section 120 of the Karnataka Land Revenue Act 64, any person acquiring by successions, survivorship, purchase, mortgage, gift, inheritance, partition, lease or otherwise, any right to holder, occupant, owner, mortgage, landlord, or tenant of the land shall report orally or in writing his acquisition of such right to the prescribed officer of the village within 3 months from the date of.
Yes, I've seen the order.
These are the findings of the trial court,
I have seen
appellate
that.
court,
I
my
have-
lord.
I have
The appeal
seen
has been dismissed. The trial court also has come to the same conclusion, my lord, coming to the conclusion that the mortgage has been redeemed.
According to the appellate court, the plaintiff has produced the documents to show that the revenue entries and all, to show his possession. And when the mortgage deed is of the year 1962, no steps are taken by the defendants to enter their name into the revenue records.
Please.
Prima facie for an injunction, yes, prove the case. Now, what is your case now?
My case, my lord, it is not in dispute, my lord. Certified copy of the mortgage deed is produced by the defendant along with the written statement. And the trial court also has agreed that the defendants along with the written statement and list of documents have produced certified copy of the mortgage deed. If your lordship can peruse the mortgage deed, the handing over of possession as on the date of mortgage deed registered in favor of the mortgagee is crystal clear. Possession was handed over. Till date, the petitioner's defendants are in physical possession of it and they are raising the
What
crops.
is it they have shown?
My lord, they were villagers and illiterate, they were not knowing all these proceedings. They are
But
continuing in
ultimately,
possession.
when the prima facie, the plaintiff could prove something. And when you're saying that in the light of that mortgage deed executed in the year 1960, and you're in continuous possession until 2050, when is the suit? Till 2014, there could have been some material, but even the land tax receipts and all also from 62 are paid by the plaintiffs. And the plaintiff's case is that they have paid the money, and that's how the position is given back to them.
But as a mortgage deed, a registered document, my lord, no, there is no
No, the court is-
registered redemption proceedings.
No, court is not looking at a declaration of the title. It's only a suit for bare injunction. Court can only look at it. Please come.
My lord, one submission. my
Yes.
lord. Now, the evidence of both the sides have been completed.
Hmm.
Now the suit is for hearing the arguments and passing the judgments. So without taking into consideration the observations in the impugned order,
No,
the
that
trial
will be
court may
required.
kindly be given
That will
liberty
be- that will be
to
required.
pass a judgment on merits of the case.
Yes, the agreed with the orders passed in MA number 20 of 2015 dated 18th November 2017, whereby the court had confirmed the orders passed in IN number 1 invoice number 109 of 2014 dated 16th April 2015. The defendant is before this court. The respondent herein, who is the plaintiff, had filed the suit for bare injunction. It is a case of the plaintiff that the father of the plaintiff had executed a mortgage deed in favor, father of the plaintiff, right?
Please, please.
Father of the plaintiff.
In
has
favor of the
executed-
father of the defendant's petition.
in favor of the father of the defendant, defendant. It is a case that executed a registered mortgage dated 23/3/1961. But the physical portion of the property was not handed over to the father of the defendants. Thereafter, the father of the defendant had received the mortgage amount from the father of the plaintiffs, and both agreed to discharge share of the mortgage deed before the sub-registrar. It is their case that from 1961 till today, the revenue document stands in the name of the plaintiff's father, and after his death, plaintiffs are in a continuous possession and enjoyment of the suit scheduled property. As when the on 11/3/2015, when the defendant started obstructing and interfering with the plaintiff's physical portion of the agriculture work and for harvesting the crop, they were made to file the suit. The trial court in I number 1 dated 16th April 2015 had granted injunction, interim injunction and this injunction by restraining the defendants from interfering with the plaintiff's peaceful possession and enjoyment of the suit scheduled property till the disposal of the suit. The trial court has observed that in the recent record of rights which is produced by the defendants, the name of the father of the defendant is shown at column number 11. And as per our RRT, except the document, the defendant have not produced the document to show that their father name entered in the revenue records of the suit scheduled property. And all the revenue records reflects the name of the plaintiff's father, thereafter the plaintiff's. And the court observed that if the IA is rejected, more mischief and hardship will cause to the plaintiff than the mischief and hardship to the defendant, and accordingly granted injunction. The matter was carried in by filing MA number 20 of 2015 before the additional senior civil judge and JMFC at Chamrajnagar. The same came to be dismissed on 18th November 2017, confirming the order of the trial court in I number 1. The appellate court has also perused the revenue records where right from the date, even after the mortgage DT is executed, how the names of the plaintiff's father and thereafter the plaintiff's name is reflected. And his court has come to the conclusion that prima facie, the plaintiff could establish his possession, whereas the defendant has not placed any document before the court to show that he is in possession of the property, and accordingly dismiss the appeal. Next one. Learned counsel appearing for the appellant defendant submits that when there is a registered document, registered mortgage, when the mortgage is not discharged, it prima facie shows that the defendants are in possession of the property. He submits that he has drawn the attention of the court to the recitals in the mortgage deed and submits that there is the recitals show that the possession is delivered. When the said document is marked, and when the court has also taken note of it, both the courts went wrong in granting injunction in favor of the plaintiff. He submits that both the courts have failed to consider both the factual and the legal aspects in proper perspective, and the order needs to be set aside. Next paragraph. Learned counsel appearing for the respondent plaintiff submits that when an application is filed seeking injunction, the burden lies on the plaintiff to show that he has a prima facie case, balance of convenience and irreparable loss. He submits that in this case, the plaintiff could establish all these three ingredients and rightly court had granted injunction and rightly affirmed by the appellate court, and there are no grounds to interfere with the well-considered order passed by the courts. Next paragraph. Having heard the counsels on either side, produce the material on record. The respondent has filed the suit for a bare injunction, and he has filed an IA seeking injunction. When an application is filed seeking injunction, court will necessarily look at the prima facie case, balance of convenience, and the irreparable loss. According to both the parties, the mortgage is of the year 60 or 62? 60?
61.
Mortgage is of the year 1961. The plaintiff has filed, placed before the court the tax receipts and also the entries, the revenue entries, which are in the name of the plaintiff, thereafter plaintiff's father, and thereafter in the name of the plaintiffs. And prima facie, it shows that the petitioner, that the plaintiff could make out a prima facie case. When it comes to the defendant has not placed any documents. The contention of the land council that when there is a registered mortgage and registered mortgage, and when the same is not discharged, it cannot be said that when as per the mortgage deed, there is when the possession is delivered, there cannot be an observation that the plaintiff is in possession. As this is a suit for bare injunction and not a suit for declaration, and while considering an interim application, the court has to necessarily look at the three ingredients, and in the considered opinion of this court, at this stage, the plaintiff could make out a prima facie case. In that view of the matter, this court finds that there is no illegality with the orders passed by both the courts. And accordingly, this court is passing the following order. The writ petition is dismissed. Number 2, any of the observations made by this court or the appellate court made by this court shall not be construed as an expression of this court, and the trial court, uninfluenced by any of the observations made by this court or the appellate court, shall proceed with the matter.
Cell number 34, Sadashivaya KG for petitioner. Saman Argun for respondent.
Yes. I appear for the petitioner in the WP number 39514. 39514. Next matter. Where is Mr. Sadasivaya KG? Land counsel in the connected matter, that is WP 39514 of 2018 is present. List WP 30403 of 2018 for dismissal tomorrow. Yes, next.
Cell number 35. They are Venkatram.
My lord, serial number 35, I appear for the respondent, my lord.
Our advocate is in IBP. He's suffering from IBP. Kindly give me the date.
He's seeking time.
After
My lord,
15th.
for one or the other reason, this matter is being adjourned, my lord. Since 2000 matter proceedings are stayed before the trial court, my lord.
We'll have it on next Friday. By the time he should be here, or else we'll hear the matter.
Okay, thank you.
The party
Yes.
is present before the court, makes a submission that the advocate is suffering with illness. The land counsel for the respondent submits that on one pretext or the other, matter is being adjourned. Finally, lists this matter on next Friday. On that time, no further time will be granted. Yes.
Thank you.
Yes, my lord. Grateful.
36. Sandeep Lahiri.
Lord, there's some emergency list, my lord. Senior family emergency, this some adjournment, my lord.
We'll have it on 23rd. This is matter on 23rd at the request of land counsel for the petitioner. No further time. Yes.
Cell number 37. For the petitioner, I'm going to withdraw the petition.
You want to withdraw?
Yes.
Yes.
Connected matters.
You will file a memo?
All the, please, ma'am.
When will you
I'll-
file?
It is ready, I'll file it in account.
Then tomorrow we'll have it.
They are here.
Huh? Take it.
3 connected matter is there.
Let's see.
Ah.
Filed by you. You are the petitioner in all the matters?
Yes.
You are for the petitioner.
Please.
Not ready to proceed with petition. And the petitioner. Yes, the memos are filed. Memo is filed by the petitioner seeking to withdraw the petitions. Accordingly, the memos were taken on record and all the 3 petitions are dismissed as withdrawn. Yes, next.
Cell number 38. statement.
Please certificate.
38,
Petition and discussion.
Prasanna, VR,
But the defendant's petition.
Rajshekar,
Who appears for the respondent?
Rajshekar,
Ready?
Hello, can I speak?
Huh?
Senior is another country, my lord. So-
Passover?
Passover.
Passover?
Yes.
Yes.
Not if they are not, ಬರ್ತಾರಾ senior?
ಒಂದ್ಸತಿ call ಮಾಡಿ.
Otherwise, any other day, not so much. Suppose
Respondent, list is marked tomorrow, no further.
interim order will not expire today.
Interim order, look at it, if it is there, extend it till tomorrow.
adjourn,
Please.
serial number 40, adjourn, serial number 41. Gauri Shankar C, for petitioner,
No representation
H.T. Jagannath,
for dismissal, day after tomorrow.
serial number 42.
That I appear for respondents 7 to 10 or 7 to R10.
Petitioner. in
What
this.
about other respondents? They are not filed wakala.
Others, they are not filed.
R7 to R10 and R12 go, CG Gopalaswamy
Please, madam.
are held sufficient. Vishal, yes.
Yes, madam. My petition for transfer of petitions to the common court under section 24 of the 24 of CPC has been dismissed. Against that order, my lord, I am before the court. My lord, I filed a suit for partition and declaration.
Come to your prayer, where is that prayer?
uh,
So, what is this miscellaneous number 59?
59 of 2018 is section 24 petition, ma'am. Application that was, petition was filed before the district court.
No. Yes, so OS number
OS number
17 of 2018 is filed by?
filed by, filed by,
You are the plaintiff in which suit, 18?
I am the, my 19, my lord, 19 of
OS
2016.
number 19.
19 of 2016, I am the plaintiff,
Civil Judge JMFC at Sringeri.
Shingeri.
What is this suit for?
This suit for partition and declaration that partition deed executed among the family members is not binding on me. This OS number 17 of 2018 is filed by 7th respondent.
Herein.
Yes, madam. R7 to R10 are the plaintiffs in
Seventh
OS
respondent is
17
the
of
mother.
2018.
What is that suit for?
That suit is for declaration.
That
Declaration and injunction.
Declaration and injunction.
in respect of the very same property.
Very simple.
No.
That
No,
is
my
the
lord.
subject matter of,
We'll hear, yes.
that is the subject matter of the original suit in 2016 of 19 of 2016.
Then what is OS number 18?
OS number 18 is also the similar suit filed by another member of the.
Who is that?
The,
Which
who is
respondent?
that Ravindra, that is Chandrasekhar, that is the 12th respondent.
He's representing him also?
Yes, maybe.
No, I don't represent him.
You don't represent them.
I represent only R7 to R10.
So you have to take it that OS, no, this 18 of 2018, the plaintiffs have no objection then.
8.
Then now,
They have not stated in so many words before the other court.
no, they have not come to the court. They have not representing. Then
Please, madam.
that's how we have to take it.
Maybe their conduct may show that.
My lord, kindly turn to my lord.
First of all, take the court to the plaint in.
Yes,
OS
my lord.
number
Plaint is at annexure
No,
A, my lord, in page number
19.
19, my lord. That is annexure C, my lord. Annexure C is the 18 of 2018.
Tell the page numbers.
Page number 34, my lord. In page number 34. Annexure C,
This is the plaint. Please come to the prayers.
pair. Wherefore, pair is at 36, my lord. Last. The plaintiff wherefore prays for judgment and decree against the defendant as follows. To declare that the plaintiff is the absolute owner in possession of the scheduled properties. For permanent injunction, restraining the defendant either through himself or agent or servant from disturbing the plaintiff's peaceful possession and enjoyment of the scheduled properties. I am the defendant number 2 in that petition, in that suit, OS number 18. Defendant number 2, Satish.
Then come to the
Another
19,
petition,
17.
17, my lord, it is at annexure D, my lord, in page number 39.
Hmm?
In page number 39, D, annexure D, 39.
Hmm.
That is the 8th respondent. My learned friend is representing 8th and 9th and 10th. That is the 17th. This is the similar petition. The prayer is also.
There are several other survey numbers. 152 is there, 78 is there.
73 is there, madam, my lord. 152 is there, 71.
In first OS number 18,
Yeah.
survey numbers are 79 and 73. When it comes
yes.
to OS number 17, the
Yeah.
survey numbers are,
Yeah.
additional survey numbers are 152, 78, 76.
76.
Ah.
These are
This
two.
is the suit for
This is the suit filed by the respondent number 8.
also declaration.
Declaration and injunction.
Now come to your.
Now come to my suit, my lord,
Where is it?
at annexure A in page number 13, my lord. It is in Kannada.
Numbers will be in English.
Yes, yes. The plaintiff is the Satish, my lord, in the top.
So what is the relief? You
Relief
sought?
is a part, my lord, it is in relief. Relief is for partition. Davasatu Samantha Vadia Bag
And
partition,
declaration
1/24th share, my lord.
Declaration that the other partition deed is not.
That is the partition deed executed in the year 1980 without including my family. Because I lost my father in the year 1972
No,
when I
let's-
was kid.
Let's see what is the schedule of the property.
Yes, my schedule, my lord. I will compare with the schedule 2, my lord.
Page number.
Page number 20, my lord.
So you have included so many.
So many, there are 20 schedules are there.
73, 69, 76, 72, 79, 71, 75, 8, 266.
78, 8 and yes, my lord.
No,
260.
please come to the order.
266 is the residential house, my lord.
Come to the order in the miscellaneous.
Yes, my lord. Now, my lord, before my lord, compare these schedule with the schedule of the my petition, my suit, my lord. In kindly, my lord, page number 37.
So we'll go to the miscellaneous.
Yes,
order. Please come to that.
Yes. Order at my lord, in page number 59, my lord.
59.
Annexure H. The 61 is the
What are
relevant.
the reasons?
After the
Para number 11.
para number 11, madam. Reasons. The case of both the parties is stated in the above para and no need to repeat it. The petitioner, along with the petition, has produced copy of the plaint and order sheet in OS number 19 of 2016, 17 of 2018, and 18 of 2018. Along with the objections, respondent 6 to 10, 12 and 14, here referred to as the contesting respondent, have produced copy of the amended plaint in OS number 17 of 2018 and OS number 18 of 2018 and OS number 19 of 2016. They have also produced written statement filed in OS number 17 of 2018 by defendant number 1, defendant number 2, and additional written statement filed by defendant number 2, defendant number so and so, petition in the said case. They have also produced copy of the written statement of defendant number 1 and 2 in OS number 18 of 2018. The order sheet in OS number 19 of and written statement of defendant number 5 in OS number 19 of 2000. Looking to the cast title, it appears some of the defendant in OS number 19 of 2016 are parties in OS number 17 of 2018 and 18 of 2018. Their rankings are mentioned in the petition filed in this case.
some of the subject matter of in OS number 19 of 2016 were common in OS number 17 of 2018 and 18 of 2018. But all the properties referred in OS number 19 of 2016 are not the subject matter of both the suits.
What is the stage of the suit that is?
It is the 18 and 19, 17 and 18, my lord, it is for cross-examination
And
of
19?
plaintiff by
19?
the defendant.
19.
19 is also, evidence has already been commenced.
Which courts they are in?
It is the plaintiff evidence, it has been stopped there.
No. One is Sringeri.
One is Sringeri and another is in Koppa, my lord. It is 25 kilometers because 18 and 17 and 18 are before the senior civil judge. And 19 of 2006 is...
You are a party in both the suits?
Both the suits.
No, you are a party in...
in both, all the three suits, I am the, in 19 of 2016, I am the plaintiff. In 17 and 18, I am...
What is the first suit?
17 of 2018 is filed earlier, my lord. Earlier it was filed.
This is 19 of 2016.
No, my lord. It was filed before at Chikmagalur, my lord. Initially it was filed. At that time it was...
Where is that?
It is 14, my lord. 2014.
Thereafter
Both the suit.
Both are 2014 suits.
2014 suit. Because initially it was filed in Chikmagalur.
And the respondents, the contesting respondents are parties to your suit?
Both the suit, my lord.
To your suit?
They are the parties in my suit also. I am the party in their suit also.
Yes.
I have a technical objection saying that this petition is not maintainable. It should have been a petition under section 24 because this honorable court has the general powers of transfer and withdrawal. It should have been a clear, direct approach to this honorable court, setting out these facts. Writ petition is an extraordinary relief which they could not have invoked. Not the fault, my lord.
No. When once an order is passed by the court below, what is the remedy available?
Concurrent jurisdiction, my lord. Your lordship also can independently look at it.
And even this is also like this is.
Well,
like
it could be treated very well. It could be treated as a petition under section 24.
Yes.
That's why I only submitted as a technical objection. That's all. It's not that I am pressing it or anything of the kind. But so far as the merits of the case is concerned, my lord, not all the properties are common. Just 3 items are common in these petitions. Kindly see the schedules in both the 3 suits. But in OS 17 of 2018, except survey number 78, 70, 76 and 70,
8 and 6 in OS number 17. OS number 18, it is 79 and 73.
Yes, my lord. 79 and 73 are not part of the schedule of OS 19 of 2016. Which my learned friend is...
No, 79 is part in OS 19.
79 part,
Yes,
I do not see that
79 is there. 79 and 73, both are there. What is not there is 152.
Yes, ma'am. 152 is not there. And the other claim, 152 is not there. 73 is also not there. 73, which is part of OS 17 of 2018, is not part of OS 19.
That's the first number in that.
73 is there.
73 is the first number.
Yes.
Where is
page number 37, my lord.
Oh.
37.
If you look at page number 37,
One.
That's the first property.
The second one.
No, yours in Kannada, where is that?
73, my lord. In page number 37, my lord. Their suit. My suit, it is 73/1. It is mentioned.
No, in your suit,
it is mentioned as 73.
Mr. Raviraj, in your suit, there have been a lot of blanking with ink. Number of items have been blanked with ink. So that either the survey number or the extent is available.
No, not that. The page number which he is not mentioning is not correct. The page number is...
it is 42.
Page number 20.
20, it is my suit.
Your suit only is referring to?
Yes.
If you see at page number 20,
yes,
serial number 2?
Serial number, no, in the copy that is given to me, what is seen is number 1, serial number 1. Then 2 and 3 have been blanked out. There are no survey numbers.
But here it is there, 73/1.
Yes, my copy doesn't show that, my lord.
Why you given a separate copy to the council?
I just highlighted it, my lord. It is in like this. It was given earlier, my lord. Later I highlighted in my petition.
Anyway,
They are
the
also parties to the proceedings. They have the copy, my lord.
It doesn't look like highlighting it. It looks like you have struck it
No,
off.
my lord.
blanked it out, my lord. As
They
if
are all the
stuck off
parties
that.
to the original suit, my lord. They have the copy, no?
Yes.
And the other two suits are in advanced stage. Is it still at stage of preliminary hearing? Is what that was on preliminary issue. Probably the preliminary issue framed is regarding the limitation or probably evaluation. Is maybe the preliminary hearing. But the point is, the cross-examination stage has reached in the other two suits, and he has a number of times it had been posted for cross-examination, and he avoided it, putting forth the plea of getting the case transferred. So this is the situation. I'll leave it to your lordship, my lord. It is his case that is being transferred to the cases which we have filed. So we may not be put to any additional disadvantage. I'm not on that for a moment.
Because no, it is going to, no, we'll transfer this case to that court.
Theirs is before the civil judge, junior division.
Junior
Our
division.
cases
Their
are
cases
before.
to be forwarded to your, why?
Yes.
For pending there, we'll transfer your case to that court.
Yes, ma'am. That is what, ma'am.
In fact, he has prayed for transfer to COPA, where my cases are pending.
Now it is.
Then no disadvantage for you.
Yes.
As far as we are concerned, we may not be put into any disadvantage. It's not, maybe it's more convenient.
The
But
senior civil judge is sitting in Sringeri itself. Now we have.
Now your case will be transferred to
Transferred
the
to
70 with,
yes,
along with tried to be
Yes,
tried along with
yes,
17 and
yes,
18. Please come.
Because they are claiming under will.
Yes.
The only question is the pecuniary jurisdiction. My cases are pending in the senior civil judge's court. His case is pending before the junior civil judge.
And when he has added so many properties, for how is it pending before junior civil judge?
I don't know, my lord. They only revenue annihilation.
No.
He has valued it on the.
His three properties.
Yes.
His three properties.
Yes.
Are you are already included in your suit.
My suit.
And his his case is pending before the senior civil judge. How come your case is pending before the junior civil judge?
My suit is for partition, my lord. That is why it is before the juniors. Their suit is for declaration and injunction.
Let it go. Anyway, you want it. The present petition is filed. Agreed by the orders passed in miscellaneous number 59 of 2018, dated 21/6/2019, whereby the court had rejected the request of the petitioner to transfer voice number 19 of 2016 pending on the file of the civil judge and JMFC at Sringeri to the court of civil judge, senior civil judge at NR Pura, sitting at Sringeri, to be clubbed along and to try along with voice number 17 of 2018 and voice number 18 of 2018. The facts of the case are both the petitioners and respondents are the lineal descendants of one late Chinnagowda. The respondents number 7 to 10 have filed a suit for declaration before the senior civil judge and CJM at Chikmagalur, which was numbered as OS number 110 of 2014, seeking declaration that they are the absolute owners of the property on the basis of the will executed by Sri Chinnagowda. Later, the suit is transferred to the Court of Senior Civil Judge at NR Pura and renumbered as OS number 17 of 2018. And on the same day, respondent number 14 had filed OS number 111 of 14 before the senior civil judge and CJM at Chikmagalur. And that was also transferred to Pura and renumbered as OS number 17 of 18. Both the suits were clubbed together and a common evidence is let in. Thereafter, the petitioner herein had filed OS number 19 of 16 against all the parties and the other two suits, along with other family members seeking partition, and also a declaration that the earlier partition is not binding, correct?
Yes.
The earlier partition is not binding on him. The petition herein had filed a petition under section 24 of the CPC before the principal district and session judge at Chikmagalur, seeking transfer of the suit, seeking transfer of his suit, that is OS number 19 of 2016, to the senior civil judge court, Pura, to try along with OS number 17 of 18 and OS number 18 of 2018. That came to be dismissed by the order impugned, whereby the court has observed that the suit or the other two suits of the year 2014, whereas the suit of the petitioner is of the year 2016. All the properties in the suit filed by the petitioner are not the properties in the other two suits. As such, there is no necessity to transfer the suit, pending suit filed by the petitioner. Petitioner aggrieved thereby, the petition is before this court. Learned counsel submits that when the old disputes are between the family members, and when all the parties or the parties in the other suits also, in that case, the court ought to have transferred the same. But without considering all these aspects, court had dismissed the petition. Next, learned counsel appearing for the respondent. Not the respondent. The respondents 1 to 5. 1 to 5. Respondent 1 to 5 and 11 to 13 were served, and they have not, no advocate is engaged by them, and the notice to R6 and 14 is held sufficient, and R6 and R14, R6 to R14 held sufficient. Learned counsel appearing for respondents number 7 to 10 and 12 submits that their suit is a prior suit, which is of the year 2014, and now it is at an advanced stage, and only with an intention to drag on the proceedings, the present application came to be filed. Learned counsel submits that the petitioner could not make out any grounds for transfer of the case from the junior civil judge Sringeri to senior civil judge Pura. Next, and the petition is liable to be dismissed. Next, having heard the counsels on either side, peruse the material on record. The undisputed facts are that all the parties are related to the other. Some of the properties are common in the suit filed by the petitioner and the other two pending suits. If any order is passed by one court, there will be conflicting of judgments if these cases are dealt with by the different courts. The reasoning that is given by the district court in dismissing the application is unsustainable, looking at the interest of parties and also to avoid conflicting of judgments, this court deems it appropriate to withdraw OS number 19 of 2016, pending on the file of the Junior Civil Judge, NR Puram.
Shingeri.
Huh?
Shingeri.
No, your case is on.
Shingeri, madam.
The pending on the file of by a civil judge and JMFC at Sringeri and transferred to the senior civil judge at Annapura, sitting at Sringeri, to be clubbed along with, to be tried along with OS number 17 of 2018 and OS number 18 of 2018. Next, number 2, the petitioner shall not seek unnecessary adjournments and shall proceed with the matter. Accordingly, order dated so and so is set aside and the petition is allowed. Yes.
Number 43.
Much obliged.
I appear for the petitioners, my lords. Lords, the short point, my lords, is that my IA, my lords, for the cross-examination through video conference, my lords, was dismissed on the ground that there is no technical support available to the court. And also, my lords, there is no document.
Or the plaintiff or
I am the plaintiff, my own suit.
why the plaintiff should be through video conference?
My lords, I stay, my lords, in USA. My job is there, my lords, in USA.
Come down sometime.
My lords, I'll seek instruction, my lords, whether he is.
Because the prime witnesses.
Please.
And that though we have the facilities of video conferencing.
Please.
Then I passed one more order also. At present, with all the facilities we have, it is not possible. Number 2, demeanor of the witness is very much important in all these cases.
Please.
And on that count also, there can't be any video conferencing.
Please.
Find out.
I'll find, because this is in 2019, my lords, I'll find out whether there's any chance that.
Stay nothing.
There is stay, my lords. My own suit, it's been stayed. I'll just seek instructions, my lords, whether.
When?
Lords, 1 week or.
Let's just matter on next Friday.
Please, my lords.
Number 44.
Interim order may be extended.
Interim order earlier granted is extended till then. Yes, 44.
Number 44. Siddhappa BM.
I'm appearing for the petitioner, my lords.
Hmm.
In the worst case, the client has been suit itself is disposed of, my lords. That petition become infructuous, my lords.
When counsel for the petitioner submits that the suit itself is disposed of and the petition has become infructuous, dismissed as infructuous. Is 45?
Number 45.
Petitioner, my lords. So can take this matter day after tomorrow, my lords.
Day after tomorrow.
Much
At the request of land counsel the petition.
Interim order maybe.
Interim order. Look at it. If it is there, then only extend. Yes.
Number
46.
Your lordship, day after tomorrow, your lordship. Day after tomorrow.
Day after
Much.
tomorrow. 46.
46. Manu NP.
My lord, appearing for the petitioner, my lord.
Yes.
Kindly pass over your, my lord.
Pass over.
Number
Or-
47.
Kindly pass over your, my
47.
lord.
Pass
and,
over.
46 pass over, sir. 47. Veena Arun.
No representation for dismissal tomorrow.
Sale number 48. Amresh A. Angdi for petitioner.
Petition.
AG Nagaraj. For this one.
Shall we have it after lunch? It's already 1:29. After lunch. Serial number 13.
ಹದ್ಮೂರ
ಹೌದು
ಒಂದ್ ನಿಮಿಷ ಯಾವ್ದೋ ಒಂದು ಪಾಸ್ವರ್ಡ್ ಆಯ್ತಲ್ಲ 46 ಅಲ್ಲ ಒಂದ್ ಸೆಕೆಂಡ್ 13 ಏನ್ ಬೇಕು 13 ಅದು ನೋ ರೆಪ್ರೆಸೆಂಟೇಶನ್ ನಾಳೆ ಡಿಸ್ಮಿಸಲ್ ಅಲ್ಲಿ ಇದೆ ಅಪಿಯರ್ ಆಗಕ್ಕೆ ಹೇಳಿ ಇಬ್ರು ಇಲ್ಲ ನೀವು ಇಲ್ಲ ಅವರು ಇಲ್ಲ ನಾಳೆ ಡಿಸ್ಮಿಸಲ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ನಾಳೆ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಒಂದ್ ನಿಮಿಷ ಹಾಕಿದ್ದಾರೆ ಮೆಮೋನಾ ಫೈಲ್ ಎಲ್ಲೋ ಇತ್ತು ಆ ಡಿಸ್ಮಿಸಲ್ ಯಾಕೆ ನಿಮಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅನ್ನ ಏನೋ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದಾರ ಅಷ್ಟೇ
ನಮ್ ಡಿಸ್ಪೋಸಲ್ ಒಂದು ಕೊಡಿ
ಯಾವ್ದಾ ಸೀರಿಯಲ್ ಅದೇ ತೆಗ್ದಿತಿ 45 ಅವ್ರ ಗಾಯಬ ಆಯ್ತಲ್ಲ ಡೇಟ್ ಅದು ಹಿಂದೆ ಒಂದು
ಇದೆಲ್ಲ ಅವ್ರಿಗೆ ನೀವು ಫಸ್ಟ್ ಅದ್ ಮಾಡ್ಸ್ಕೊಂಡ್ ಕೊಟ್ಬಿಡಿ ನಾನು ಎಲ್ಲ ಬರ್ದ್ಬಿಡ್ತೀನಿ
ಆಯ್ತು ಹಂಗೆ ಮಾಡಿ ತಗೋ ಅದು
ಇದೊಂದು
ಡಿಸ್ಪೋಸಲ್ ಒಂದು ಬರಿಬೇಕು
ಅದೇನೋ ಇದಲ್ಲ
ಅದೇನೋ ಮೆಮೋ ಒಂದೇ ಒಂದು ಮೆಮೋ ತೆಕ್ಕೊಡು ಎಲ್ಲ ಒಂದೇ ಗ್ರೌಂಡ್ಸ್ ಇದೆ ಅದರಲ್ಲಿ ಮೆಮೋ ಒಂದ್ ಮೇಲಿನ ಫೈಲ್ ಕೊಡು
ಮೇಲಿನ ಫೈಲ್ ಕೊಟ್ಬಿಡಿ ಬೇಡ
ಆ ಮೆಮೋಗಳು not interested in prosecution ಅವ್ರಿಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು
ಕ್ರೋಮ್ ಇದೆಯಲ್ಲ ಅದನ್ನ ಓಪನ್ ಮಾಡೋ.
ಅಲ್ಲ, ಇದು ಜುಡಿಷಿಯಲ್ ಚೇಂಬರ್ ಪ್ರೊಸೀಜರೇ ಸರಿ ಹೋಗಿಲ್ಲ. ಈಗ ಅದೆಲ್ಲ ನಾವು ರೆಫರೆನ್ಸ್ ಏನ್ ಮಾಡ್ಬೇಕು? ಅವತ್ತೊಂದು ದಿನಕ್ಕೆ ಲಿಸ್ಟು ಇವಾಗ ಪ್ರೊನೌನ್ಸ್ ಆಗಿದ್ದು ಇನ್ನೊಂದು ಏನಾದ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇತ್ತು ಅಂದ್ರೆ ಏನು ಗೊತ್ತೇ ಆಗಲ್ವಲ್ಲ ನಮ್ಗೆ. ಹೋಗಿದ್ರಾ? ಏನಂತ? ಮುಂದಿನ ವಾರ ಯಾವತ್ತಿಗೆ? ಥರ್ಸ್ಡೇಗೆ.
ಡೇಟ್ ಏನು ಹೇಳಿಲ್ಲ ಮೇಡಮ್, ಕೇಳಿದಷ್ಟೇ.
17 ಫ್ರೈಡೆ ಒಂದೇ ದಿನ ಮೇಡಮ್.
Up to 16th. Pass
over matter, serial number 46. Manu NP for petitioner, Venkatesh HN.
Yes, sir.
You asked for pass over, or the respondents asked?
Myself,
Huh.
morning myself asked.
Huh. Who appears to the respondents?
HN Venkatesh.
We'll take up to tomorrow. Others are not there. Huh? Any difficulty tomorrow?
Next week, ma'am.
No, I'm asking any difficulty for you tomorrow. This is matter on 22nd January. No representation for the respondents. At the request of non-cons for the petitioner. Yes.
My lord, interim order.
Intermodal granted is extended. Look at it. Yes, next.
Serial number 50.
For the respondent bank in this matter,
48.
The-
Serial number 48. Serial number 48.
Yes. Yes.
And defendant petition. The plaintiff has filed this suit in respect of three items of house properties. According to him, item number 1 and 2 belongs to the plaintiff. Item number 3 belongs to defendant. Defendant construct a building without leaving setback. That is his case.
What is the suit for?
I am for the defendant.
Suit for?
Suit for a bare injunctions. No.
Restraining the defendants from using the passage. No,
Then the defendant not put up any construct in my property.
in your property, in the plaintiff's property.
They are not touching his property. I have constructed the building as per the approved plan obtained by the competent Panchayati authority. And that when the setback is concerned, it's only jurisdiction rests to authority. If I violated any setback area, it is left to them, the local authority, to take action. Not the civil court has no jurisdictions according to me. So
Under which provision? Under which provision? No, for example, if there is any unauthorized construction or somebody is encroaching upon the neighbor's land and making construction.
Encroaching?
No, I'm just saying, if somebody is has encroached the land of the respondents and made some construction, that is also within the realm of the municipality. Even in those cases also, people do file cases for injunction, which are maintainable. What is this exceptional one? They have a remedy to go before the authorities. And how, whether in the municipal act, like any other act, it says that whatever the powers that are conferred with the municipal authorities, the jurisdiction of the civil court is barred. There is no such provision under the Municipalities Act.
The Municipality Act is clear, Your Honor.
No, any bar.
Section 60, not bar. In section 60 for the Panchayati Act, it is clear that any violation left a setback. It is waste.
No, it is not something like an alternative remedy, like how we look at it under 226. And unless and until a particular act bars the jurisdiction of the court.
No, I'm not, they obtain injunction, I'm not that. They can ask the police protection.
Have they impeded the municipality also as a party?
No, Malad. They ask a police protection, the police came and asked my client to come to sit in the police station. That harassment is going on.
If that harassment is going on, then your client's remedy is somewhere else.
And the police
If the
protection.
police are harassing your client.
He asked for the direction of the court. This is police.
What is the direction of the court?
Court is given a police protection to see the impugned order, that is it.
Yes, let's see the impugned order.
The order passed by the trial court, Your Honor. I have filed an application under order 39 roll.
Injunction is granted. That is not questioned.
Yes.
Not question.
Not question.
Not question. Because I have constructed building already before the obtained.
Let us see what is the first, what is the interim order?
Yes,
Injunction. Where is the interim injunction?
Yes. 39 roll.
To page 20 for the operative portion, my lord. The application filed with the applicant.
No, not this one. Injunction that is granted.
I'm not questioning injunction.
No, you're not questioning. Court should understand what is the order passed by the court.
The order court is not put up any construction.
Where is that order?
Maria, I am not challenging.
You have a copy of it?
For 13 now.
Page number?
They have produced the order sheet. In that page number 13, Your Honor. in the order sheet of trial court.
3030.
13.
13.
Yeah,
Where is 13?
they have produced entire order sheet of
entire
the
order sheet
fiscal court. In that page number 13, Your Honor. 41B.
Refer to the date.
3/7/2019.
37.
2019.
Order on,
Yeah.
page 41, ink page 41.
41.
The IA filed by the plaintiff under order 39(1) and 2 of CPC is hereby allowed. It is further ordered that the defendants are restrained from putting up any further construction over the eastern side of the item number 3 of the suit schedule property till the disposal of the suit. This is the order passed by the trial court.
The defendants are hereby restrained by an order of temporary injunction from putting up any construction in the suit scheduled property in favor of third party. What is
Constructed
that?
over eastern side of this item number 3 of the suit schedule property.
No, what is this in favor of third parties? Read the order.
No, it is not in the order. In the page number 13, I'm reading.
41. I have.
No, my lords.
It's
Page number 13.
13.
Look at his pagination. I can't look at your papers. 41 is the order.
No, my lords. This is the order.
There is a mistake, Your Honor. I have given a copy of this, but there is a different statement.
That order says property in favor of third parties. What is that order? The defendants are hereby restrained by an order of temporary injunction putting up any construction in the suit scheduled property in favor of third parties. What is that order?
No, here it is the same way. Property till the disposal of the suit. In favor of third parties, it is not in.
Please serve her the copy of this petition, proper copy.
Hello, what have you, I have taken order sheet, entire order sheet. I have produced it.
Some problem with what she has. She has to refer to
Before that, one submission. Just 1 minute.
you that.
Order sheet, your honor, order sheet. Page 57, your honor. Page 57.
That is a typed copy.
Typed copy. Yes, sir. Order dated 26/6/19 was last pair. 26/19.
That is something you have this, when it comes to this neat copy, you wrote something else. This is the original one.
Yeah.
That is at page number 41.
Yeah.
And this is a typed copy.
Typed copy.
No nexus between the two.
No. I'm only referring order dated 26/19, your honor. At page 57, ink page 57. Typed copy. You want to see the typed copy?
So the difficulty is the original till 43.
Then
You have typed what is there till 43. Is
no,
it not?
I am referring some other order.
Which order?
Order 26/6/19. You are on taken 49, page 49 after you take it. You are. Page 49. Order dated 26/19, you are on. 26/19, got it.
Heard both sides on IAS at this stage, stating that to withdraw, which is
Withdrawals at IA under
hence in view of the memo IA number so and so permitted to withdraw.
The police protection has been withdrawn on particular date. Again, the order has been passed.
It's not about that. Court wants to understand the facts. What is the injunction that is granted? What is the police protection that is sought? Why is it granted? Why is it, what is this? First of all, what is the order that I want to know?
That also my submission in on 26/19, they filed before that, they filed application on 115 CPC for police protection to implement the order of temporary injunction, not to put up any construction. Then you were on 26/19, they withdrawn that application, filing a memo. Yes. Again, the order has been passed.
Kindly turn into the page number 87/2019, Your Honor. Again, I have filed a similar application under order section, under section 151 of CPC seeking police protection, Your Honor. It is clearly shows in the order sheet produced by them itself.
No, that advance case, you are advance the
Yes,
case.
Your Honor. Again, on the said application, the order has been passed.
Just like that, you withdraw and you can file.
Earlier, I have filed a memo to withdraw the said application, Your Honor. Later, advance the matter.
No, you have given any liberty to again file the same application. Please, with all the papers, with
Yeah, Your
full
Honor.
preparation,
It's
both
no-
of you please come back.
Please.
List this matter on 3rd of February. Yes. With the request of both the parties. 51.
Number 49 adjourned, 50. Hello.
Yes.
H.S. Basavaraj.
Yes, I'm waiting
for
petitioner.
For the respondent number 5 bank in this matter. R1 to R4 are dispensed with.
At their request.
Yes.
What is IA?
The impugned order is at page 53, annexure K.
50?
53, annexure K. Lord, the facts of the case is the respond number 3 and 4 availed the loan from the petitioner bank on 9/12/2001 and 21/12/2011. They availed the 40 lakh
Hey,
rupees.
Permitted to give the dates of events.
Yes.
Copy is given.
Lord, kindly permit me to file my written submission so that it's copy, sir. R1 and R2 are the loanee, and respond number 3 and 4 are the guarantors. And R5 is the.
No, the simple issue is this. What do you say about you're the fifth respondent.
I am the fifth
Fifth respondent is a bank. Under the Surface Act, proceedings are already initiated. Are you entitled to initiate the proceedings before the civil court? Or are you supposed to be part of the Surface proceedings which are already initiated?
Please. My lord, the HDFC Bank has initiated the proceedings before the DRT and under Surface Act.
In respect of a particular property.
Yes, property in question. Later on, the petitioner hearing and the respondent 5 has impleaded in the before the DRT. The DRT has passed an impugned order. On 17/2/2016, annexure E, page 27. Sorry, this is the execution. 25/2. After interim order, what the interim order says from the DRT is, you have the liberty has been given to the respond number 5 to sell the property. And the whatever the process, sale confirmation should not be done till further orders of the DRT. That is on 17/8/2012. This interim order is passed on 17/8/2012 in SA number 505 of 2012. The specific order of the DRT was the respond number 5 herein has to sell the property on 22/8/2012 at 3 p.m. Kindly, I may permit to produce the order.
I understood the order. Then what happened?
Please, my lord. But before that, on 1/8/2012, there was a meeting between among the financial institutions. And all the institutions have taken a paper publication on 3/8/2012. In that paper publication, petitioner is also one of the party. Respond number 5 is also party and other financial institutions. After that, on 9/8/2012, the respond number 1 and 2 against the respond number 1 and 2 herein, we have initiated the recovery proceedings before the Honorable JRCS under section 70 of the Karnataka Cooperative Societies Act, which is at Annexure B, page 19. On 18/8/2012, the JRCS has passed an order of ABJ, attachment before judgment of this property, which is in question.
How can it be? When you're a party before a court and there already attachment is done.
Earlier to we approach the DRT by pleading ourselves. We have initiated the proceedings under section 70 of the.
No, please tell the court before you go in all these details.
Please.
No, when they have initiated the surface proceeding.
No, it is dismissed for non-prosecution on 25/2/2013.
No, I'm asking, when was it initiated?
17/8/2012 is the
Surface
impugned order.
proceeding.
Impugned order.
What impugned order?
That is the, sorry, interim order. Interim order to liberty is given to the respond number 5 here into sell that property.
When is that?
17/8/2012.
2005.
2012.
2012. So when an order, interim order is passed on 17/8/2012, you were a party to the before the DRT, and an order was passed. That order is never questioned by any of the parties. Thereafter, according to you.
No, before that, before this initiation, interim order of the DRT, already we have initiated the dispute before the JRCS on 9/8/2012.
No, there it is like this. Passing order is one aspect. When the proceedings are initiated, that I'm asking. Surface proceedings are when are they initiated?
May I kindly see my synopsis? On 31/3/2012, I have issued a demand notice. 31/3/2012. I have issued a demand notice. Thereafter, 6/6/2012, I have issued a portion notice under section.
Proceedings were initiated.
Yes.
That is a reckoning
What
date.
was on? Then sale notice I have issued. That is on 14/2/2016. Thereafter, property has been sold. And there are 8 banks total.
Yes.
We have appropriated the sale proceedings in pro rata basis. After the proceedings have been concluded, based on the JRCS award, he approached the civil court on execution proceeding. In execution proceeding, he moves an application for a garnish against respondent number 5. And the notice was served on me on the garnish application on 26/2/2016. Whereas the auction was taken on 19/2/2016. Sale certificate was issued on 24/2/2016. And the same day, the proceedings have been appropriated by all the banks. After this, the notice on a garnish application was served on me, which is on 26/2/2016.
By the time no amount is with you.
At that time, I don't have any money with me. Everything has been appropriated. The trial court observation is very clear. On my kindly see at para 12 onwards.
I've seen Para 13, 14.
Para
15,
13.
16.
He himself on his own volition has given up his claim. And now he is beating back.
Yes.
Trial court has made it very clear at the time of issuing a garnishee notice, no money of the judgment debtor was left with the respondent number 5. Therefore, the application was rejected on merit. Against that order, he has come on a writ petition. I leave it to your lordships to pass an order on this.
May I answer? My lord, interim order from the DRT is on 17/8/2000. And that, ma'am, SA 505 of 2012 was dismissed on 25/2013 for non-prosecution. Now they initiated the sale proceedings in the year 2016 based on this interim order. So how on infructuous order, how they can conduct the sale?
Issue is here, you want a garnishee order to be passed. By that time, the court has categorically given a finding that there is nothing with the garnishee. So what the court will do?
My lord, see, in execution proceedings, the powers of the court is very limited. But my submission is
that the court will not go into it.
Yes,
That is a different
Yes,
aspect
yes.
altogether.
Yes.
Whether under what power they have done the sale, whether there was an order subsisting.
Yeah.
All those things are open to you to agitate before the appropriate forum. Not as far as this order of the civil court is concerned, it is a considered order. The court cannot do anything.
So, my lord, my humble submission is, when garnishee's notice was served, you may kindly see, the execution is filed on IA number 192, impugned orders. Okay, our application was filed on 20th February 2016. And 30th/4/2016, common objection filed by the respondent number 5. Then 24/7/2019, impugned orders are passed.
The auction fails, there is no bar to go ahead with a fresh auction. The Secretary Session.
No,
He is talking about the old sale notice which has become infructuous.
No, sale notice was become infructuous and interim order becomes infructuous. And based on the relying on the same impugned order, they conducted the sale. You may kindly, they have published the public notice.
No, again, you're going back to the very same thing.
Yes.
Can I decide all that? That's not impugned before this court. Whether the sale that is conducted by them is right or wrong, it is for you to assail.
Yes.
Which you have not. No, as far as this order is concerned, that is perfect, legal and valid. And your writ petition has to be dismissed. Please come.
At least to agitate my liberty may kindly be granted.
What liberty?
Public money.
Your
And
lordship's
without
observation
any,
is already observed by the trial court.
without any.
Trial court has already observed that same observation.
Nobody has to tell you. You have a right. You have a right. You have a for that any remedy that you go. The agreed with the orders passed for execution number 522 of 2006 in IA number 1 and 2. And execution number 522 of 2016, dated 24th day of July 2016. The petition is before this court. The petitioner who is a decree holder has filed a petition
Execution number 522 of 2016. Is that page 53 of the writ petition?
Yeah, that's what I'm.
My written submission.
That also I'll record. Where is the application filed by them before the trial? Which page number?
Is that page
Lord,
47 onwards, Your Honor?
They have filed an application
On 16/2/2019.
for the attachment of the residual sale proceeds to the extent of 70 lakhs out of the sale of the property of JDR number 1 under the Surface Act as per the public notice dated 14/1/2016 in the auction held on 19/2/2016. The court, by order impugned, had dismissed the said application. And while dismissing the application, the court has observed that that the decree holder has not participated in the auction proceedings, and the other creditors have participated in the auction sale proceedings. The sale proceedings had been appropriated with the other creditors who were present at the time of the auction sale proceedings and also at the time of registration of sale certificate in favor of the successful bidder. Court had considered the scope of Rule 46C of the CPC and observed that in order to attract the provision, as on the date of receipt of the notice, the amount belonging to the judgment debtor was in the possession of the garnishee, whereas in the present case, as on 26/2/2016, no amount was due in the hands of the garnishee, which is payable to the judgment debtor. The sale proceeds has already been apportioned with other creditors on 24/2/2016. In view of that, the garnishee cannot be called upon to pay the amount due to the judgment debtor into the court. The court further observes that the role of the garnishee is very limited. If an amount is there in his hands payable to the judgment debtor, then that amount has to be deposited by him, and the court can attach only the said amount. Then the court cannot go beyond the scope of the proceedings and give a finding regarding the validity of the auction sale conducted by the garnishee. Further, if that all the decree holder is agreed with the auction sale conducted by the garnishee, he ought to have challenged it before the proper forum and not filing the execution petition before the court. Accordingly, the court had dismissed the applications. Learned counsel appearing for the petitioner has submits that that an interim order was passed for DRT on 17/8/2012 for conducting the auction. Then on 25/2/2013, the application itself is dismissed for default, but they have conducted the execution petition is filed on 20/2/2016. Auction was conducted on
19/2/2000.
34/2002.
19/2/2016.
19/2/2016. 19/2/2016. It's a submission of the land council that when the main, when the SA is dismissed, what is that application number?
SA, securitization application.
The SA, when the SA itself is dismissed for non-prosecution, all the interim orders that are passed also, and the interim orders will also go with the petition. And as the same is dismissed for non-prosecution, as on the day when the auction was conducted, there was no authority for the respondent bank to conduct the auction. In spite of it, they've conducted the auction. It is his case that when as on the date when the application is filed by them, the amounts are with the respondent bank. And the court ought to have passed an order. It is further submitted that
the property is attachment but before judgment in the year 2012 only.
it is a case of the petitioner. It is then counsel submits that the garnishee totally disobeyed the orders of the civil court and has sold the subject property under the lapsed DRT order and issued the sales certificate to the auction purchaser on 24/2/2016. It is stated that the Surface Act is not applicable to the garnishee, which is a state cooperative society of Karnataka state, and could not have auctioned the already attached property in favor of the petitioner by the JRC way back on 18/2/2012 under the Surface Act. it is submitted that the order impugned is contrary to law and the same is liable to be set aside. Next paragraph, when counsel, this court had the notice, the risk of the petitioner, notice to respondents 1 to 4 is dispensed with. When counsel appearing for the respondent number 5, bank submits that the trial court had rightly dealt with the application and rightly held that there is nothing in the hands of the garnishee as on the date of the as on the date the order is passed, and when as per the application that is filed under under as per Rule 46A of CPC, the powers of the court are very limited, and the court cannot pass any order. He submits that the court has rightly dealt with and passed an order, and there are no reasons to interfere with the well-considered order passed by the court. Next paragraph. Having heard the counsels on either side, produce the material on record. The application that is filed by the petitioner is that
Page 37 even. Of the writ petition.
to seeking a direction to attach the residual sale proceeds of about rupees 70 lakhs out of the sale property of JDR number 1 from and the direction is to the bank. As rightly observed by the court, as on the day, no amount is lying with the bank, and all the amounts are apportioned between the creditors. The land counsel of the petitioner was mainly thirsting upon the fact that the sale that is conducted by the bank is illegal, as on the day the order that is the essay that is filed by them itself, by the time long back, the essay filed by them is dismissed for non-prosecution, and they have no authority to conduct the sale. The submissions that are made are beyond the scope of the application that is filed by the petitioner decree holder. If at all, as rightly observed by the court, he is aggrieved by any of the sale that is conducted by the bank and it is contrary to law, he ought to have questioned the same. Those things cannot be agitated in an application filed before the court. And the court had rightly observed that as on the day, as there is no amount lying with the bank, there cannot be an order by the court. In the considered opinion of this court, the court had rightly considered all the aspects and had dismissed the petition. Accordingly, this court is passing the following order. The petition, the writ petition is dismissed. Next two, the petitioner is always at liberty to avail the appropriate remedies, if any, provided they are provided they are well within the limitation and the yes.
Great.
Yes, please.
So number 51. A. Ravi Shankar, petitioner Chandranath Dariga.
Seek for a passover, my lords, for only one reason, my lord. The petition may not survive. For this reason, that the same the suit, my lords, in which an IA was filed, which was subsequently challenged in MA, and that order is under challenge. The suit was dismissed for non-prosecution. Seek for a short passover, my lords.
I don't think passover. Now he has showed me the order uploaded in the e-courts stating that the suit itself, it is dismissed for default. But I don't know whether the application has been filed or restored.
28th of January.
Please.
That is-
Interim order subsisting maybe.
Interim order earlier granted, look at it, if it is there, extended.
If it is so, Millet, if it is dismissed, I will file an application to withdraw to revive the
Whenever
petition
the-
after.
Yes,
Great.
thank you.
Till number 52. VN Jayadeva for petitioner.
Appear for
Petitioner.
respondent in this matter, my lord.
In this matter, I representative for the petitioner, my lord. I seek for 1 week time because it's the personal inconvenience my senior colleague. I start for a short accommodation, my lordship.
My lord, I have an objection unless there is a date fixed, my lord, because this.
We will have a date for that. List this
Please.
matter on 24th January. At the
And the
request
extension
the-
of interim order, my lord.
At the request of land counsel, the petitioner, no
The-
further adjournments will be granted. Look at it, if the interim order is there, extended, then the next date of hearing. Yes, next.
I do oblige, my lord.
53. Kashina JD for petitioner PN Harish for respondent. Respondent number 1. Respondent number 1, please go there.
I'm up here for the petitioner, my lords. Petitioner is the plaintiff before the trial court, my lords. She has filed the suit for declaration and mandatory injunction, my lords. The order impugned herein is, my lords, I have filed the IA for recalling and reopen of the stage for cross-examination of the defendants. That has been rejected by the trial court. Suit of the year 2010, my lords.
Suit is of the year
2010.
When the evidence of the plaintiff is concluded,
Evidence of,
you are the plaintiff or the defendant?
I am the plaintiff, my lords.
When the defendant's evidence is concluded?
Defendant evidence, my lords, on 10 to 2017, they have filed the evidence affidavit and cross-examination was taken as nil on 21 to 2017. By that time, my
When
lords,
is the application, your application to recall and
application
reopen?
for recalling, my lords, on 5/9/2019. I will narrate the facts, my lords.
Till such time, what are you doing?
Please, my lords. Suit was filed in the year 2010, my lords. After completion of plaintiff evidence, the defendant came before the trial court and they have filed the memo stating that, my lords, valuation which has arrived before the trial court, that has been not, that is not sufficient. Then they have filed the memo disputing the court fee, my lords. The trial court directed the plaintiff to pay the deficit court fee. Thereafter, my lords, on 10 to 2017, the counsel for the plaintiff, he filed the retirement memo, my lords. That has been allowed on the very same day the defendant led their evidence and marked the several documents. After that, my lords, on 21 to 2017, the cross-examination of the plaintiff defendants are taken as nil. Thereafter, my lords, on 26/8/2017, again plaintiff represented by the counsel, he filed the NOC Wakalat, my lords. Thereafter, my lords, he paid the deficit court fees and he filed the application to produce the documents which were on the custody of the defendant number 4. That has been allowed, my lords, and trial court has directed to produce those documents, but the defendant was not followed the order, my lords. Thereafter, my lords, IA was filed on 5/8/2019, 5/9/2019, seeking to recall and reopen of the states to recall the
2010 suit, even filter 2009. How many years do you want to continue?
2018, I have filed Wakalat.
You are filing no objection Wakalat. They filing the applications, filing.
On that time, my lords,
those are
court
all
fee-
not the those are all not the considerations. When in 2017, when the defendant's evidence cross-examination is taken on nil, why were you waiting till 2019? What are the reasons that you have stated? Are not the reasons?
Please, my lords, I have filed the NOC Wakalat, my lords.
So whose problem is that?
At the time.
So whenever a new advocate files a wakalat, that's the reason. For filing a no objection wakalat cannot be a ground at all. That's for your client.
But
here it is not about
the
the
very
advocate.
same day, my lords, the defendant was
Why
led
did you
their
not file an
evidence.
application immediately?
Kindly, my lords.
Why have you not filed the application immediately?
Defendant, because, my lords, defendant has raised the objections regarding the court fee, my lords. After that, I have filed the
They are
IA.
two different things.
Kindly
They are
note.
two different things, sir. Let them do whatever they want to do. For you, it is, you have to ask for the recall and reopen. And you can't ask after 2 years.
Kindly, my lords, after the,
Will not come
kindly, my lords, kindly pass over, my lords, senior will come.
tomorrow. Heard in part. List is matter tomorrow as partner.
2013, there is an order to pay the court fee. That has not been completed.
2019, what is paying the deficit court fees, sir?
2013 order is completed in 2000.
I will hear it tomorrow, partner.
Oblige. Interim order may be.
Interim order, look at it. It's done. Any signatures?
Signature ಮಾಡ್ಕೊಂಡು